Good afternoon, folks. According to my notes here, there's over 6.5 hours of argument requested. And I imagine you folks don't want to be here late into the evening. So I on behalf of my colleagues, really request that you ask for the time you need to convince us of your most important points. You do not need to educate us about your appeal. We are a hot bench. Just one note of housekeeping. When there are 2 minutes left in the argument, a silver white light comes on. 2 minutes later, red light. If you're finishing up your thought, finish it up. If my colleagues have questions, they will continue asking questions. The red light is for you folks, not for us. First case on is People versus John Curtis. Submitted. Anonymous versus anonymous. No. I'm just calling the calendar. Is the appellant here? Come up, please. Could you? Okay. How much time do you need? You'd like to submit? I'm sorry. How much do you wish to submit your appeal? Meaning, we won't hear argument, or do you want argument? Okay. How much time do you want? 15 minutes. Okay. With you folks, I guess starting from the left. Who do you have? Which you have the union, the teams. Which you're the union? Okay. How much time do you need? I'm sorry, you want 15 minutes too? In total, you want 15 minutes. Okay, this is what I'm going to do. 5 minutes to the appellant, 2 minutes rebuttal, and I will give you folks 6 minutes, however you want to divide it up. Okay? We are aware of the arguments, so again. Third case on is Olivia, submitted. Yolo versus 95th Avenue owners. 5, 2, and 5. People versus Jamie Guerrero. Submitted. Protek versus Jokar Realty. 3 and 2. 3, 2, and 3. Starnello versus Ganty. 5, 2, and 5. People versus Wilkins. 4, 2, and 4. Gilchrist versus Your First Home. Okay, so 5, 2, and 5. Innovative Securities versus Obeck Securities.
Your Honor, I represent one appellant, Prime.
Well, let's start with the plaintiff. The plaintiffs. How much time? 5 and 2. Okay, you got it. And starting next with Prime has a cross appeal. Who's Prime?
No, Prime has either the cross appeal or the main appeal, yes.
Okay, who's Prime? How much time?
Oh, so I'd like all three, Prime, Odex, and Callan, 8 and 4.
I'll give you 6 and 2. And who else do we have?
For the Callan respondents, 3 minutes.
Okay. We got everybody? People versus Johnson.
For appellate, 5 and 2.
5, 2, and 5. Ocean Trails versus MLN. That's plaintiffs? Okay, I got a lot of parties here, so and a lot of the arguments are going to be similar. So please do your best to separate them as much as you can. So I'm sorry, starting with plaintiffs. Okay, I'll give you 8 and 2. Then there's MLN Middle, who has?
I represent those parties as respondents and cross.
How much do you want?
8 minutes, please.
Do you really need 8 minutes, you think? Okay. Okay. I'm not going to short circuit it. And then the participating lenders, who's that? You just, well, don't you, you have a cross appeal too, right? So you want 2 and 2? Because you're entitled to rebuttal, you have an appeal, so 2 and 2? 2 and 2, you got it. And then Credit Suisse.
2 minutes, Your Honor.
And you have a cross appeal too, correct?
We do, but don't intend to argue on the cross.
Well, okay, so I'll give you 2 minutes. So it's plaintiffs 8-2, MLN Middle 8-2, participating lenders 2 and 2, and Credit Suisse 2. Thank you.
There's one more party, Searchlight, but I'll be conscientious and just take more.
1 minute for Searchlight. Okay. Commissioners, State Insurance versus Z Builders. Submitted. Pena versus Rhodes. You don't have an adversary. You want to submit, or do you want to argue? 2 minutes. Wickstra versus 304, 306 East 83rd Street. That case has been withdrawn. Messer versus Hughes. This is a non-enumerated appeal. Was time requested? You were granted time? Okay. How much time do you want? 5 and 2. Okay. 5, 2, 2 and 2, 5. Orella versus 115 Enterprise Group, submitted. And Antonio versus Santa Mona is submitted as well. First case up is Anonymous versus Anonymous. Ma'am, why don't you stand up? Okay, so I will give you 5 minutes. Get to the podium.
Thank you very much, sir. Thank you very much, Your Honor, for allowing me this time to come here for this case, Anonymous versus Anonymous. As you know, the argument for today stems from the League's fraudulent inception of Article 616F and their collusion with media giants like CNN and Wall Street Journal to spread unsubstantiated lies about me, and also lying about the FBI's involvement in my case to obstruct justice, to aid and abet unlawful retaliation against me, and to assassinate my character. In some of the evidence that no court has ever seen, there are several emails that these respondents essentially got together and conjured up a plan to spread as much lies about me as possible. I'm going to quote the email exactly. The email says, we need to weaken her as a witness. So essentially just contact as many people as possible in the media to spread as many lies as possible. And one thing you would notice if you go on the internet and search up this case, every single lie they spread was not substantiated. For instance, CNN said she has a long history of fraud, but they never included not one document, not one testimony to back that up, right? And I think this is very important because, as you can see, I'm standing here as a pro se litigant. I don't have an attorney. Why? I called over 30 different attorneys. No one wanted to represent me. They all said, oh, the FBI is investigating you, which is completely false, by the way. But they believed them because these are multi-million-dollar institutions telling the world that the FBI is involved, the FBI this and that, which also turns out to be false. So They successfully assassinated my character, and in the process of doing so, they attacked the NYPD. They called the NYPD reckless and shameless. This is also on the news, and then they attacked U.S. Navy in the process. So not only did they come for me, they came for everyone who aligns themselves with me in the process. And today, I want the court to decide what happens when big institutions like the League creates a law and states anyone who is a victim of sexual assault, domestic violence, or child abuse can come to us and we would investigate and provide resources. Now, as you know, their side argued that I cannot come up for them because I'm not a third-party beneficiary of their law. And they also said that their constitution does not extend to members of the public. So now the case is, why did you include the public? You specifically wrote in your law, Article 616F, which states any member of the public who is a victim of sexual assault, domestic violence, and sexual abuse can come to us. So I want the court to decide today what happens when they include us. And one more thing before I go, because I see the light is off. Article 31.7 in their constitution says that the US justice system has the right to step in and arbitrate a case. So not only did they include certain members of the public, they also included the court. So I would like for the court to decide what happens when they include us in their constitution. Can they now back out and say, oh no, you're not a part of a beneficiary? So it's my time up, sir?
You have another minute and a half.
Oh, the light makes me think it's
It's the
up.
red light.
So to conclude, my thing is, if these respondents commit all these atrocities, right? They collude with the media to spread lies about me. They weaponize the FBI. They did all these things. And then when it's time for accountability, they say, oh, no, you can't hold us accountable because you're not a beneficiary of our Constitution. How is that okay? You have to remember, this league is the most powerful basketball league of all times in human history. And many American kids look up to them, aspire to be part of them, aspire to be one of them. So what are we doing? And how are we allowing them to get away with this? It should not be allowed. And let's remember, part of this case is going on in federal court. It's sealed. So we should not dismiss this one. Instead, I beg the court, I plead with the court to, instead of dismissing it, to either send it back so that the court can see all these evidence that the court hasn't seen before, and also allow the FBI the chance to reply, because the federal court is asking the FBI to respond to their claims. So it will be, I think, the right thing to do on behalf of the American people, especially fans of the league, to be able to see these evidence before dismissing the case. Thank you, Your Honor.
Thank you. Okay, so I've given you folks 6 minutes. Have you divided it up?
We have, Your Honor.
So what's your division?
I'm going to try to do it in 4.
In 4? Yeah. Okay. Look, if you need more, I'll give more, but but go ahead.
It's okay. Thank you. May it please the court, plaintiff, counsel. Your Honor, my name is Stephen Cobry, and I represent the League as we've been designated in the proceedings below. I plan to address just briefly the claims against the League that have been raised below and were dismissed, which were 4. One for negligent infliction of emotional distress, the other one aiding and abetting unlawful retaliation, deliberate indifference, and military status discrimination. The first 3 claims are common to all 3 of the defendant appellees, so I understand they're going to join my argument on it. I'll leave a couple of minutes for them to, there are some specific arguments, I think, that are specific to the other defendant appellees. First is, many of the things that the court heard in appellate briefing and also today, while allegations that are we would take as serious, are beyond what was in the record below, and not even considered by the court below, we think is inappropriate for consideration at this stage in this court. I would, if I may, just sort of flip quickly to sort of the main claim, let's call it, which is the negligent infliction of emotional distress claim. That claim is one that is essentially based on the language of the collective bargaining agreement between the League and its union. As plaintiff notes, the plaintiff is not a party to it. It's not an intended third-party beneficiary to the CBA. And therefore, there's no legal duty that's owed to the plaintiff, and therefore the plaintiff cannot sue under the CBA. In addition, negligent infliction of emotional distress is not one that can be based on a breach of contract. We lay out the reasons why the plaintiff is not a intended third-party beneficiary. Some of the most obvious that jump out is the CBA does not provide an independent basis to enforce the terms on behalf of a third party, nor does it actually provide a basis for damages as well. It has its own mechanisms for relief as it relates to the players and also to the league.
What's your position with respect to the provisions cited by the appellant?
First of all, Your Honor, again, the plan itself, which basically is intending to address concerns like sexual harassment and otherwise, sets up a mechanism for complaints, but also for discipline that, and a whole regime for that, that's intended to be applied to the players and to the league, the union and the league itself, not to fans or other individuals who might have been affected. Excuse me?
Or the general public?
Or the general public. And then also, just specifically, if you're referring, Your Honor, to the provision as it relates to reporting, which says anyone who thinks that they're a victim of harassment or otherwise is encouraged to call and report it, and where there can be a conversation about various services and otherwise. It really is just that. It's sort of an encouragement that this is something that's available to people to call and raise. I think the court below acknowledged the fact that even the services that are listed that can be discussed, security and counseling and otherwise, are actually not even things that members of the public are entitled to, or certainly that the CBA envisioned that members of the public would be entitled to. Merely that they're encouraged that if they are a victim, they can call and they could seek out basically to speak to somebody about it, which frankly, based on the allegations of what happened, that is actually what happened. She actually called and did speak to somebody from the league. The issue is that the plaintiff wasn't satisfied with the reaction from the league and was concerned that they were dismissive and didn't investigate in the way that she wanted to. But as the lower court acknowledged below is, it still doesn't provide a right of action to sue under it. So I see that my time is up. Unless there's any questions, I'll step aside.
Okay, so who's next? You're the union?
No, good afternoon. Elizabeth Velez on behalf of the Southern team. I joined in all of the league's arguments, which equally apply to my client, but also wanted to address the issue of personal jurisdiction and the Southern team's proper dismissal for lack of personal jurisdiction. This was an argument that was not addressed on appeal, and so it's been abandoned by the plaintiff. And so just as a reminder, it's undisputed that the Southern team was never properly served in this case, and that long-arm jurisdiction does not attach to the Southern team because it did not transact business in New York by playing the occasional basketball game here, nor did it commit a tortious act within or without of the state, because all of the acts alleged and attributed to the Southern team occurred in Texas. The court's lack of jurisdiction over the Southern team should obviate the need to address any arguments on the merits, regardless of any evidence that plaintiff may have, suggested exists. But I'd also like to address another issue, another cause of action that was alleged as to the Southern team and the Northeastern team, and that's for breach of contract. There, too, the trial court correctly held that the allegations were too vague and indefinite to sustain a claim for breach of contract, and especially as to the Southern team, the facts were actually inaccurate because the Southern team did not recklessly speak to the media, but explicitly declined to publicly comment on the situation. Otherwise, I rest on my briefs, and I'm happy to entertain any questions that the court may have.
Thank you, counsel.
I'm here on behalf of the Northeastern team. I'll be very brief. We join in the Southern team's arguments and the league's arguments. The only unique claim brought against the Northeastern team was a claim for fraud forgery. It was not briefed in the appeal, so we think it should just be dismissed. And otherwise, we agree with the lower court's decision.
Thank you.
Kelly McGee on behalf of the union. We would similarly join in on the league's arguments and rest on our papers. Thank you.
Thank you. Okay, so I will give you 2 minutes to respond.
Thank you, Your Honor. I she made a false statement saying that the Southern team did not say anything, which is false. They did release statements, several statements to the public. And also, one of the emails that the court hasn't seen is where they coached Mr. Cuban, Mark Cuban, on things to say. Mr. Mark Cuban was completely blindsided by the lies they fed him. You would see it in the email. And what I'm trying to understand is, how do they think they can just do all these crazy things, coach Mark Cuban to go on TV and on the television and lie? Their own attorney also released a statement. It's on the internet. She said they didn't, but that's false. They released a statement saying that the girl is lying, that they investigated, but they never investigated. They did not contact me. That's why I brought this case against them. I didn't bring it necessarily because of the CBA. I brought it because of the involvement, what they did behind the scenes, how they conjured up lies and involved the FBI and lied about the FBI's involvement. That's why I brought this case. I feel they committed serious crimes and they should not get away with it. That's what I'm trying to say. And let's remember, the CBA states it's only for the parties, which is, in this case, the union, the league, and the players. I understand that. But they included the public when they made promises to the public, when they said anyone can come to us and report this. And they also promised the public a hotline to call. That hotline does not exist. So my thing is, how does a company as big as this make these promises, blatantly lie, and then say, oh, you can't hold us accountable because you're not a party to the CBA? I'm trying to get the court to see that if they willfully chose to include us, they did not include all members of the public. They included 3 people: victims of domestic violence, victims of child abuse, and victims of sexual assault. That's not all members of the public. That's 3 specific groups. And then they included the court. They said the court can come in. If you look at Article 30.7, they included this court, the justice system. So what happens when they willfully included us? We didn't put a gun to their head and say, include us and make us these promises. So I want the court to decide. Yes, the CBA, we know members of the public cannot come after them. But what happens when they include certain groups of people and the court in the CBA? That's what I want the court to decide today. Thank you very much, Your Honor.
Thank you, folks. Yolo versus 95th Avenue. Fifth owner, excuse me. You may proceed, counsel.
Okay. Good afternoon, Your Honors. My name is Jerry DeCamp. I'm with the firm of O'Connor, Red Orlando for the defendants' appellants, 95th Owner LLC and TriStar Construction Corp. The basis of defendant's appeal is seeking a reverse.
Isn't this a classic labor law case? Painter on a bucket? I mean, how many cases do we have with painter standing on upside-down buckets?
No, and a couple of reasons why it is not your standard painter on an inverted bucket case. For one, the lower court assumed and took as gospel basically plaintiff testimony only. For example, in footnote 2 of the decision order below, it states that Central Painting had no ladders on the site. Carlos Reyes is his supervisor, and he was subpoenaed as a non-party witness, and he testified that he arrived immediately after the accident, and plaintiff was still there at the site of the accident, and within the vicinity was a Central Painting ladder. He also testified that from the start of the project to the end of the project, throughout the whole duration, they had at least 1 scaffold, as well as 3 A-frame ladders, 4 foot, 6 foot, and an 8 foot.
Mr. Reyes wasn't there at the time of the accident,
He was
correct?
not there at the time of the accident, Your Honor, but with respect to he brought the ladders there. They remained there for the duration of the project. It was over 2 floors. There were only 2 painters working for him at the time, and he had 3 ladders. So this isn't even, a lot of times you'll see in these labor law cases, there were not sufficient number of ladders.
The ladders were in the I guess the supply room that was assigned to the painting outfit?
It wasn't that they were in the supply room. He said when he arrived, there was actually a ladder, a Central Painting ladder right there in the vicinity of the plaintiff. So plaintiff is saying there were no ladders there. And the lower court adopted that when not considering any of the evidence that the defendants put in to refute his prima facie showing of entitlement to 240. I'm sorry, I thought you were speaking.
I'm just trying to understand your testimony, because maybe we read it a little bit differently. You're saying that in that same room where he was painting and caulking, there was a ladder, and
Yes.
that was Mr. Reyes's testimony?
Correct, it's
What page on the record is that?
record at 614. There's testimony that when he arrived at the scene, there was a central painting ladder there.
Okay. Didn't the plaintiff testify that he spoke to Mr. Reyes, explained to Mr. Reyes he needed the ladder, and Mr. Reyes said, get it done?
That is
And then Mr. Reyes, I'm sorry, Mr. Reyes then testifies that he doesn't recall speaking to the plaintiff, but he doesn't refute speaking to the plaintiff. He just doesn't recall it.
Later in his testimony, at the record at 625, he actually says that plaintiff did not call him. He first had said, I don't remember that, and then he said, no, he didn't have a discussion with him about that. So there is further testimony with respect to whether or not there was a discussion, and at the
He never testified, though, I'm sorry to interrupt you, Counselor, it's in my nature as a judge and a mother. He never testified that he instructed his client never to stand on a bucket, correct?
He did not testify to that, but he said that that was an unsafe practice and he would not support that in the work that Central Painting was doing on that job site, and everybody that testified to that stated so. Also, Mr. Blandini had testified that he was not there on that day as well, but he had worked with the plaintiff the day before. They worked on 9-foot-tall columns, which plaintiff acknowledged they worked on 9-foot-tall columns, but yet he testified that there was never any ladders on the site. So how does one at 5'7" work on 9-foot-tall columns when now he's claiming that there were never any safety devices or ladders on the site? And which just goes again to the credibility.
One question about that.
Yes.
The superintendent, as I recall, Mr. Haddock,
Yes.
he saw plaintiff on a bucket.
Yes.
And he tells him to get down, and maybe they had language issues.
Correct.
Does Haddock say that there was actually a ladder in the room?
I don't believe Mr. Hudak said that there was actually a ladder in the room. I know the electrician.
When did the ladder come? So
He didn't specifically say there was or wasn't.
there was no questions asked about whether or not there was a ladder in the
I believe there was testimony that there were ladders in the room because there were also electricians. I don't think Mr. Hudak did an investigation at that moment to say, is this an electrician's ladder? Is this your ladder? When he arrived and he saw the plaintiff. He just saw him on the bucket. He tried to speak with him. There was a language barrier. He tried to motion to him to get down, and he got a no comprende, and that's where he had left, and he went down to the other floor. Again, though, too, at the end of the day, we have conflicting testimony from Mr. Reyes and from the plaintiff. So at the very least, it should be an issue of fact. Let a jury decide who to believe, whether or not there were ladders there. And that's with respect to the 240 claim. On the Labor Law 200, the court, in its decision, had said that the Labor Law 200 is dismissed as to the defendants, but then in its summary had only indicated that it was to the owner. So it's just respectfully submitted that the 200 claim should have been also dismissed as to Tri-State. There's no dispute that they did not direct and control the work. And at the very least, general supervisory control over safety provisions does not count to means and methods. Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent.
Could you address the argument raised here that Reyes actually testified that there was a ladder in the room where your client was performing work on a bucket?
He did. He didn't say, but here's what he said. The problem is they're taking the testimony and they're twisting it. My client said, 302 of the record, that he asked the electricians for a ladder, and the electricians told him to go take a hike, which is absolutely congruent with Mr. Hudak's testimony. And I'll give you the pages. On pages 536 to 537, that contractors were not allowed to share ladders. Here's what Mr. Reyes said, and I'm going to read it because I don't want to interpret it.
What page?
On page 626, now you took the manuscript, so it's 626 and page 72 in the manuscript. I'm going to read it to you, starting on page 16. Question: did the other trades you observed on the floor where you found my client, after his accident, were there any ladders that were being used by those trades on that floor, meaning any other ladders on the floor where you got there? Answer: there were ladders on the floor, yes. Question: who did those ladders belong to? Answer: not me. This is the star witness. They could be ours. It could be the other trades. So the testimony is absolutely consistent. My client said that he wanted a ladder. Reyes told him to work on the bucket. Reyes, when asked, as Judge Rosado said, he said, I don't recall the conversation. He didn't say it didn't happen. He said he didn't recall it. And he went up and he had a triple elevation-related hazard. He's standing on a bucket, on top of a radiator, and then there's brown paper on the radiator when he steps down and he goes into a hole. It's a perfect 240 case. And in fact, if you, as you point...
But that goes to your prima facie. The question is whether or not there are issues of fact on the recalcitrant worker defense.
There is none, because there's no proof...
So you're saying that Reyes' testimony was equivocal as to whether or not it was the central paintings ladder.
I just read it to you. He said he didn't know because he wasn't there. I don't have to tell you how many cases you have saying you need personal knowledge, you can't have speculation. And Hudek's testimony was even...
But Reyes presumably goes after the accident, goes to the room. So wouldn't that be on personal knowledge?
Yes, but of whose ladder? My client never said there wasn't a ladder there. He said there was a ladder there, 302 of the record. He said it was electricians. They wouldn't let him do it. So just use basic summary judgment jurisprudence. I establish a prima facie case. They don't rebut it with any evidence, and I'm reading to you what he said. I'm not categorizing it. I read it.
About if he was allowed to use the ladder or not, or who, because if there was a ladder there, doesn't that create an issue of fact, right?
No, it wouldn't on this case, because if you take Hudek's testimony on 536 to 538 that they weren't allowed to use it, you take the plaintiff's testimony that he asked the electricians to use the ladder but was refused, there's absolutely no question of fact whatsoever that it's there. And I mean, look, I don't have to tell you, you do more labor law cases than I do. Since 1985, the Court of Appeals decided Zimmer, you decided Oriema. The fact that there's a ladder somewhere at the site doesn't mean that the plaintiff's a recalcitrant worker.
Except if it were a central painting ladder in the room, that would conceivably raise an issue of fact, correct?
Only if, under Gallagher and your interpretation of Gallagher going from Vitucci on, where the plaintiff refused to use the ladder without reason and without excuse. Remember, the tri-state superintendent, just make sure I have his name, Mr. Danglo, 445 to 446, actually said that there was a problem at the site because my client's employer didn't have enough ladders there. So absent actual statements that my client refused to do something that he was supposed to do without excuse, there is absolutely no basis not to grant summary judgment. And I see my time is up. I would just ask you to take a look at Mr. Hudek's testimony beginning at 540, line 16, to 541, line 12. What's remarkable about it is not only does he say that the plaintiff doesn't understand him because he doesn't speak Spanish, but he left him there because there was another painter working on the 10th floor who was also on a bucket and who also didn't speak Spanish. This is a classic labor law case. It would be a travesty to reverse it. I don't have anything else unless you have something for me. I'm happy to rest on my brief.
Thank you, counsel.
Thanks for listening.
Just very quickly regarding,
I want to get back to Reyes' testimony. So point to me by page where Reyes says unequivocally that our ladder was in the room.
on 614 of the record.
What does he say?
It's a I don't have the page in front of me. I have to grab it.
Okay, that's okay.
It's 614.
So you're saying that he says unequivocally that our ladder was there,
Yes.
not, oh, there's a ladder there. I don't know if it's the electrician.
He says it's a central painting ladder.
But then, I mean, he comes 40 minutes after, and Hudak was there when it was actually going on, right? So Hudak doesn't testify that there were any ladders there because he's telling the plaintiff, you got to get off this bucket, right? He doesn't understand him because of the language barrier. 40 minutes later, if there's a ladder there, how does that raise an issue of fact as opposed to what was going on right at that moment? And we have testimony from people who are right there at that moment with that personal knowledge.
Mr. Hudak never said that he didn't see a ladder there. From his testimony, he went there and just instructed him to get down. That was his first line of practice. Come down, get off the bat. That's unsafe. You shouldn't be doing that. You shouldn't be standing on the bucket. So there was no testimony either way as to Mr. Hudak saying affirmatively there was no ladder there. It's Mr. Reyes saying when I got there was a ladder within the vicinity. Unless Your Honor.
Anything else?
No, unless Your Honors have any other questions, arrest.
Good, thank you. Thank you both. Protek versus Jokar.
Your Honors, Andrew Shea for the appellant.
Just give me a minute.
Yes.
Go ahead, counsel.
Good afternoon, Your Honors. May it please the court. This case involves an option to purchase real property, and I'm going to get right to the central issue. The lower court invalidated our client's purchase option on the basis of the rule against perpetuities, and as we've laid out in our brief, we feel that the analysis that they applied was wrong and that the purchase option does pass muster under perpetuities analysis.
So why do you believe that the tenant who's occupying those premises, that was the relevant life in being?
Well, the option became exercisable upon vacant possession. At the time the option was granted, there was a tenant in possession. Once possession was recovered from the tenant, then the option would become exercisable. So he's either what he's looked at as the holder of the prior possessory estate or a person who's causally connected to the vesting of the option. It seems very clear that that tenant possession, I think his name is Richard Keene, is the measuring life.
And then how do you address the argument that, well, it could go on forever because there may be succession rights?
Understood, Your Honor. Well, assuming there are no succession rights, only one of three things could happen, and they must have happened in the lifetime of that tenant. Either he was evicted, his lease was up and he vacated, or he passed away, which was the case. The only possible issue with respect to succession rights is actually a very fact-driven argument. That would be determined by the nature of his tenancy, and we don't know any of these things. No discovery was done. The court dismissed prematurely on a 3211 motion, feeling that the purchase option was facially invalid. It's not. There's no question that discovery has to be done into the nature of the tenancy, whether he was a statutory tenant, a tenant for years, whether there was a buyout agreement. There were so many things that could factor in to the duration.
Counsel, so you don't think that the lower court should have resolved the question of whether the tenant could serve as the relevant life and being at the pleading stage? Is that your argument?
I'm sorry, Your Honor, I misunderstood that.
You don't believe that the lower court should have made this decision at the pleading stage? Made the determination that this person was not person life and being?
That is correct. The lower court also felt, and this is another key issue in our brief, that unless a measuring life is specifically stated in the instrument creating the future interest, whether it's a purchase option or something else, if there's not a specific designation,
Does the tenant have to be named?
Absolutely not. Absolutely not. I have read all the treatises on this more than I care to. Lives in being are based on circumstances. They're inferred based on the context.
It could be a class of beings. In this particular case, the tenancy, right, being occupied by the tenant, him then being the life and being.
Exactly. That's exactly correct. And just to conclude, the issue as to succession rights is very much a fact-driven argument that, and this goes back to 1993 when this option was created. So we have to see what the law was back in 1993. With the court's indulgence, if the complaint can be reinstated and discovery can proceed, we'll get to all these issues.
Thank you. Counsel. You have a couple minutes on rebuttals.
Thank you, sir.
Let me hear from your adversary.
Luke McGrath, representing respondents. Your Honor, may it please the court. There is no life in being, not because there's an inference, it's because the choice was made to use a different measure. And the lower court below had really two holdings. One
Counsel,
was...
I'm wondering, what does, when the seller shall be able to deliver vacant possession, what does that mean?
It doesn't mean I'm inferring a life of being. What it does mean is that at some later time, if we can, whenever that is, we'll allow an option if we have a vacant property. And that is so indefinite.
Well, not a vacant property. We're talking about this specific.
This specific,
right.
but a
so
property
not
that is vacant.
this one.
Yes.
And deliver vacant possession why can't we infer that's to the tenancy that's occupying at that time?
Because that's not what it says.
But it does. The option says if there's a vacant premises, you will deliver it. And so vacancy only seems to me can occur if something the tenant does. He dies, he leaves. What else could it mean?
But at the time the seller shall be able to deliver vacant possession thereof.
Well, when can it, this is a stabilized premises, correct?
Yes.
But when can, under those circumstances, the seller deliver possession?
When there is no one in that apartment. So there could be an illegal holdover. This man could have gotten married. There could have been a fire and the whole building burnt down. There could be a million different things that could have happened.
But doesn't
And
it
at
need
the time-
discovery? Don't we need discovery for those issues?
No, Your Honor, because it's as written at the time it was written. And in that, so I'm sorry, Your Honor, go on.
No, I was just gonna, just some other issue is what about the fact that your client filed this option with the AG's office? Didn't that ratify this agreement by doing that?
No, Your Honor, because the filing was with a multiple of other filings. They had enough units sold to go forward without this unit. And this unit, the option, it would not have qualified to get the condominium status they were looking for. So that's a straw man argument that was made below, and the court rightly rejected that argument. What the court did do below was said that there's no case that says, sure, inferences, that may work, but you can't.
So why can't you draw an inference in this case for all the reasons that my colleagues have been suggesting? Or at least at the pleading stage. Maybe summary judgment is different.
Mm-hmm. Your Honor, we would say because the language is clear, and this was language that was not imposed upon Mr. Protek. Mr. Protek agreed with this language, and he could have very easily said, Mr. Keene's life. He did not say that, and the courts are not allowed to rewrite the language in order to find a shows of action so that we could go into discovery. The court has to look at the contract. There's no dispute that the purchase agreement was in fact the valid, correct agreement. And when you have a valid, correct agreement that doesn't do what the rule asks, you have no choice but to say, okay, then at best they have 21 years. And what happened here is Mr. Keene lived 28 years. So they're out of the box in any event.
So we seem to now be employing the wait-and-see approach, which the Court of Appeals has cautioned against.
Right, no, Your Honor, I agree with you, and that's good that you cautioned me there. What I'm saying is that's what in effect happened. But at the time, it was invalid at the moment because they failed to do what every real estate lawyer in New York knows how to do. If you want to beat the rule of perpetuities, then you say, here's the life and being, or at least, like in the cases that are cited by my adversary, like Fitchy. Those are the implication cases. Counsel's read them, I've read them. What the implications cases say is, we can infer the life and being because you're talking about two people and you're talking in Fitchy, you're talking about an annuity. And when those annuities run and those two lifespans run, another case cited by plaintiff where it says, my life and his life. You can infer from that language that there's the life and being, but you can't infer from saying, oh, whenever an apartment in New York City becomes vacant, because the answer is never. This is New York City. That could never happen. So I will rest now on the briefing, but the reality is this was not an inferential case because Keene was not mentioned.
Thank you.
Your Honor, I would just say that I'm not sure that our client even knew who Keene was. Well, we were just told that there was a tenant in possession. Our client wanted to do an assemblage of units. He couldn't close on this one because it was occupied. So the agreement was, and the contract was amended to state as soon as the respondents obtained vacant possession, that a closing would occur. There's no necessity to name who the tenant was. Whoever it was, irrelevant. And there's no requirement for an inference that anyone even intended a certain person to be the measuring life. The person in possession at the time, which precluded the closing from taking place, was the life and being. It's a person who's alive at the time, causally connected to the exercise of the option. It happened to be Richard Keene, but more importantly, it was the then tenant of the unit.
Well, curiously,
Sir.
The word tenant isn't even used in the modification agreement, right? It's sort of passive. There's no real reference to
No reference.
an occupant. It's just to the unit itself.
That is true, sir. That's
So
right. It's a vacant
does-
possession is what it says.
Does that doesn't that cut in your friend's favor then? That where is the clear implication of a measuring life?
The measuring life would be whatever would be preventing the vacant possession. What could that would be a tenant. When we get to discovery, and I think that's really the key to this case, I think it was premature of the lower court to dismiss this based on a perceived facial invalidity. Let's do discovery. Let's get to the banker's boxes that they have and the leases and who the tenants were, and we'll get to all these questions. And then, if summary judgment makes sense, that could be done. It's just too early in this litigation to dismiss the complaint, based on the fact that a measuring life, wasn't specifically designated, because under the law, it doesn't have to be.
Thank you. Thank you,
Thank you, sir. Thank you.
Carello versus Ganty. Whenever you're ready, counsel.
May it please the court, Sarah Zilkowski for the defendant appellants. It is respectfully submitted that the Sommer Matters motion for summary judgment should have been granted in its entirety and all claims asserted against it dismissed, as the record is devoid of any evidence that Somers Manor breached any duty of care owed to the decedent. The lower court probably determined that Somers Manor had satisfied its burden of proof in its moving papers and established that it had not breached the duty of care and was not the proximate cause of the decedent's death. However, the lower court erred in considering plaintiff's expert affidavit and determining that same created an issue of fact. In countering Somers Manor's prima facie showing of entitlement to judgment as a matter of law, the plaintiff failed to present any proof, one, that the decedent fell on May 6th while a resident.
So the records do say fall, right?
The record.
I know that I recognize that he was found on the floor with a pillow under his head, and one could make a different inference on that, but the record does say fall.
The record does indicate in the notes that it was
It's
a
your
fall.
motion for summary judgment. Aren't we required to draw all inferences in favor of plaintiff? And wouldn't this be an inference in favor of plaintiff based on the records that there was a fall? I recognize that the bruising is old as well, which goes to your favor.
Well, the evidence establishes that it was an unwitnessed fall. It was an inaccurate description of what occurred. The resident was found on the floor of his room with a pillow under his head. His vitals were checked. There was no sign of any injury, any sign of impact, no sign of bleeding or any traumatic injury sustained to the decedent. And the nurse who was the attending nurse who was testified in this litigation clearly testified that nobody knew how the decedent came to be on the floor.
Oh, I understand that, but let's just for the purpose of my question, giving plaintiff the favorable inference that there was a fall. In your view, has plaintiff's expert raised issues of fact as to whether the fall was a proximate cause of death?
Well, that was going to be my next point. There's no evidence that whatever occurred on May 6th caused or contributed to the decedent's death. The record establishes that the decedent had a laundry list of comorbidities, including high blood pressure, diabetes, dementia, and the death certificate that was signed established that his cause of death was cardiac related. It was not
Also,
related.
what do you say to the court's decision regarding possibly an issue regarding whether he should have been more closely monitored after the alleged
The record establishes that he was monitored. Can
you tell me what was done?
Well, his vitals were checked again at 11:30, 12:37, and 3:55 again. And although the plaintiff's expert, undisclosed expert, has opined that more should have been done, they failed to link to what could have been done and how that could have been led to life-saving measures for the decedent. The statements were purely conclusionary in nature, and such conclusionary statements should not be allowed to rebut our prima facie showing of entitlement to judgment.
Sorry, but with respect to proximate cause, was the plaintiff's expert's affidavit devoid of any opinion on proximate cause?
Correct.
So the expert didn't offer any form of opinion on cause, great or small? Just avoided the issue or failed to discuss the issue?
We believe that the plaintiff's expert did not address, throughout the plaintiff's expert affidavit, it was referred to as unwitnessed fall. So if there's an unwitnessed fall, that's a fallacy that there was actually a fall to begin with. Plaintiff was found on the floor. His vitals were checked. There's no evidence that Sommer Manors departed in any way from the standard of care that was owed to the decedent. And the cause of death was not related in any way to this alleged fall from the bed. While plaintiff's expert opines that more should have been done following the fall, they failed to come forth with any evidence that the failure to do so was the proximate cause of this death. The death was ruled to be cardiac related. There was no autopsy performed, and as such, the plaintiff decedent's cause of death as a matter of law was cardiac related. There's no evidence whatsoever that he sustained any sort of injury the evening on May 6th. There's no evidence whatsoever that we've departed from, that Somers Manor departed from a standard of care. They did continue to check on the decedent's vitals, and co-defendant, the doctor, was actually dismissed from the case, and I did cite it in my brief. But in that decision, the same judge ruled that the plaintiff's expert failed to consider the other comorbidities that could have contributed to this to the decedent's death.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Jason Levine for the plaintiff respondent.
Following up on my colleague's question, your expert says at essentially the last paragraph of his statement that it's my opinion within a reasonable degree of medical certainty that all of the above described departures were a proximate cause of plaintiff's decedent's falls. Isn't this rather conclusory as to how does he link what occurred here?
Right. I think what the motion court did properly here was he got beyond the fact of these falls. And it wasn't just the fact that the decedent fell on May 6, 2015, which is the one incident that's still alive in this case. It's the care and treatment. Just picking up on what your question was, Justice Rosado, the care and treatment that took place after that fall, the lack of supervision, the failure to monitor going forward. That's what the court found raised issues of fact based upon the plaintiff's expert's opinion that these were constituted departures based upon the findings following that fall, where specifically the vital signs were abnormal, the temperature was 98.5, blood pressure was low, respiratory rate was low, no doctor was notified.
He had no visible injuries after he was found on the floor, correct?
Other than bruising, no.
So those are older bruises from older incidents, probably.
Well, it's not conclusive from the record, but the record does state that there was bruising and swelling found on the decedent following that fall.
It doesn't say that they were turning yellowish green?
It says yellowish green, yes.
Okay.
Yes, that's correct.
But there are two elements, and so you just very thoroughly addressed the departure prong. But I think a few of us have asked questions now directed at proximate cause. So given the passage that Justice Singh just read it toward the end of your expert's affirmation, is that sort of causation opinion sufficient to raise a tribal issue of fact, particularly in light of this gentleman's numerous comorbidities?
I would say if it was limited to the fall only, I would agree with you, Your Honor, that it would be conclusory. However, as the motion court pointed out, and is set forth in the plaintiff's expert's affirmation, he ties the failure to supervise, the failure to notify any physician, and the failure to have the plaintiff the decedent go to a hospital following this fall as departures which were a contributing factor. And that's the word he uses. I think it was about 11 hours from the fall till the decedent passed. And then during that period, he links it. And to the question whether it's conclusory, I would submit it would raise an issue of fact as it conflicts with Dr. Stallone, the defendant's expert's affidavit, because he merely says, and we would submit conclusory fashion, that it was simply the death was caused by a pre-existing condition. And he makes a blanket statement like that.
So the scope of your expert's causation opinion merely need be commensurate with the scope of the moving defendant's expert's affidavit.
I would submit he went a little beyond what the defendant did, but here I would submit, as the court found, the conflicting expert affirmations, particularly on proximate cause, raises an issue of fact.
Does your expert address, for example, the death certificate and the cause of death?
I don't think he specifically addressed the death certificate, but
Because that's where I'm having a disconnect in terms of, because this gentleman had very serious illnesses.
Right.
And I'm having trouble finding a connection between that and what occurred here. That seems to me that your guy is a little conclusory on it, right?
I would submit it would be sufficient, as the motion court found, to let a jury determine that under the complete record in this case. Again, it's a voluminous record, which it involves multiple falls, which again we're only down to one fall, in the treatment that took place after May 6th. But again, I would submit it be for a jury to resolve those issues on departures and proximate cause under the facts and circumstances and the record in this case. Unless the court has any questions.
Well, the fact that your client was found with a pillow under his head, what kind of inference should we draw from that?
Well, again, it's a question of whether or not did he actually fall, or did he himself put himself on the ground at that point in time? It's hard, again, an inference. There are different inferences that can be made from that. But again, not to beat a dead horse, but I think it's more than just the fall that occurred. The connection between the fall and his ultimate demise. It's really the failure to supervise and what took place in those ensuing 11 hours. That was a contributing factor towards the death. And I think that's how the motion court looked at it. And that's why denied the defendant's motion for summary judgment on that one limited May 6, 2015 fall and in the ensuing 11 hours. Unless the court has any other questions, I'll rest on our brief.
Thank you.
Thank you, Your Honor.
Just very briefly, with respect to the May 6th incident in question, plaintiff's expert even conceded that the bruises that were discovered on the decedent's body had been there for a long time at the record at page 879. The lower court also found that many of the times that the plaintiff's expert referred to the prior incidences as falls were also conclusory in nature and rejected them. So I'm just asking the courts to find, as the lower court did with respect to the other falls, that this May 6th fall or alleged fall was not a breach of a duty of care, it was not the proximate cause of the decedent's death, and that for all causes of action against my client to be dismissed.
Was the plaintiff's expert's causation opinion of similar quality to your expert's causation opinion?
Plaintiff's expert never came to a conclusion as to what caused it. I mean, he was also...
Well, Justice Singh did read a passage, one passage from the plaintiff's expert's affidavit that touched on causation. So it seems like the concept was at least acknowledged by plaintiff's expert. And was your expert's causation opinion anything more than what plaintiff's expert did here, which was to say, on the plaintiff's expert's hand, there was a causal link, and on your expert's hand, there was no causal link?
Well, our expert opined, he concluded that the cause of death was cardiovascular related and associated with the other comorbidities, and that could be found on the record on page 811 to 822. There are no further questions?
I think what Justice Higgett is getting to at is the legal principle, what's good for the goose is good for the gander. Thank you both.
Thank you.
People versus Wilkins. You may proceed, counsel.
Thank you. Good afternoon. For Miracle Wilkins, I'm Claire Glass with the Legal Aid Society. Mr. Wilkins was unhoused and scared when he obtained a firearm for his self-protection. And notably, the Department of Probation discussed community-based alternatives for Mr. Wilkins after the case concluded, not prison time. But nevertheless, Mr. Wilkins is serving the maximum legal sentence.
Was there a valid waiver in this case?
No, there wasn't, Your Honor. Mr. Wilkins' waiver was inadequate in several respects. So more globally speaking, this was a bare bones and brief colloquy, and at no point did the court describe the definition of the right to appeal or Mr. Wilkins' right to appellate counsel, both of which were essential for Mr. Wilkins and anyone's understanding of the gravity of waiving this right.
Was there a written waiver in this case?
There was a written waiver, but that didn't describe either Mr. Wilkins' right to counsel or the definition of the right to appeal. And, you know, for an indigent defendant, the right to counsel was essential for his understanding of the scope of waiving this right. To someone who couldn't afford a lawyer, not knowing that they would be afforded one on appeal wouldn't allow them to understand the importance of waiving that right. So for these reasons—
This wasn't his first arrest, correct?
It wasn't Mr. Wilkins' first arrest. However, he hadn't been arrested since he was, I believe, almost 18 years old. So it had been over 10 years since he would have heard a colloquy like this or had to make a decision like this. So again, this waiver was inadequate to ensure he was understanding.
Even if we were to agree with you that the waiver was insufficient, why isn't the sentence fair here? He's facing a term of 5 to 15. And he gets 2 to 4.
Well, just because Mr. Wilkins would have been exposed to more time were it not for this disposition doesn't mean that the maximum term here was necessary to pursue any approved peniological purpose. You know, and I do want to point out—
But I would note that he's had a number of prior convictions, right? And weren't the mitigating factors considered by the court when it reached the sentence given here?
Well, a few things to answer those questions, Your Honor. This isn't Mr. Wilkins' first contact with the system, but all of his prior contacts occurred when he was a minor. So this is his first adult interaction. And, you know, even the Department of Probation highlighted Mr. Wilkins' potential for rehabilitation in the community when it said specifically in the report, based on the nature of the instant offense, criminal history, and social history, the defendant would benefit from continuing his education, employment, or vocational training, and so on. The focus there was even a recognition that Mr. Wilkins had promise for positive rehabilitation in the community, and the maximum sentence wasn't necessary to ensure that he could take advantage of that potential. He demonstrated remorse and self-reflection, readily telling the NYPD shortly after his arrest that, yes, he didn't have a license and he understood that he was going to suffer consequences and be incarcerated for this mistake. And this shows that he quickly understood the gravity of this mistake he had made. And that he was reflecting. And when he spoke to the Department of Probation, he vowed never to make this mistake again. And just very quickly, Mr. Wilkins has family watching right now, just underscoring the level of family support he has. His mother has been in his life since before the pendency of this case. She raised him with his 4 siblings in Queens, and they are in close and regular communication. His brother, Tyler, is—
Do you mind saving the rest for rebuttal?
Sure.
Thank you, I appreciate it. And if you need more, I'll give you a minute or more so on rebuttal. Go ahead, counsel.
Good afternoon, Your Honors. Jacob Marcus for the people. I want to start with the waiver issue. I think here the court delivered a thorough, really error-free colloquy regarding the waiver to defendant's right to appeal. And as Your Honor noted, it was also supplemented by a written waiver identical to one that this court has called exemplary. Defendants only—
Did the court's colloquy suggest somehow that the waiver would terminate completely defendant's appellate rights?
No, it did not. It mentioned that it would bar most claims of error, but it did go on to specifically delineate the rights that did survive. It noted defendant's competency, constitutional speedy trial, voluntariness of the plea, validity of the waiver, and sentence legality, things that were also reiterated in the written waiver, which defendant signed on the record with counsel. I think defendant's primary complaint is the fact that the court didn't specifically mention that defendant would have appointed counsel on appeal, but research discloses no case from this court or the Court of Appeals that has ever suggested that's a requirement. The Court of Appeals has cautioned against that kind of mechanistic approach to colloquies. And again, I'll note, defendant's NICID report does disclose that 2 of his prior convictions were addressed by this court on appeal. So, or excuse me, by the appellate division on appeal. I don't recall which department. So he's been through the appellate process before on his prior convictions.
This was his second felony, correct?
Yes, this was his second felony.
He was considered a parole violator?
Yes, he violated his parole twice in 2017 and 2018.
Was this a negotiated plea?
It was a negotiated plea, Your Honor. As Your Honor noted, had defendant gone to trial on the underlying charge of criminal possession of a weapon in the 2nd degree, he would have been facing 7 to 15 years in prison. He came out with 2 to 4, which is less than...
And it went from a C to an E felony, in fact, right?
That's correct, a C violent to an E nonviolent. So based on all of that, I think that the sentencing court exercised its discretion. All of the mitigating factors defendant now cites were before that court, and there's no reason that defendant is entitled to additional sentence reduction from this court. So we ask that you affirm.
Thank you, counsel.
Just to pick up where I left off before I respond further, Mr. Wilkins' brother Tyler is watching right now to show his support for Mr. Wilkins.
These things weren't in place when, at the time of his plea, he didn't have family at that time?
Well, he did, and just very quickly, Lorraine, who's the mother of his daughter, is also watching today. He did have family support, primarily his relationship with his mother. However, there are a couple of differences. The pre-sentence report notes that Mr. Wilkins explained he wasn't in a lot of communication with his siblings, but as you'll see, he has made amends. His brother Tyler, or rather, he is in touch with them now. His brother Tyler is tuning in and here to support him.
Counsel, he was facing a C violent felony. He got down to an E felony with a sentence of 2 to 4. I mean, he was facing significantly more time, and he bargained for that. And maybe the court was aware of his circumstances, I would imagine, at that time, whatever existed at that time, and he got the benefit of that bargain. Why would we disturb that at this point?
Well, Your Honor, the question is what was necessary to support any valid peniological purpose, in terms of rehabilitation and community safety. And in this case, where Mr. Wilkins had this gun, though, we're not suggesting we condone it, but he had this gun for self-protection. There's nothing in the record that evinces any intent to use this. He immediately recognized the gravity of his error, and the Department of Probation acknowledged his potential for rehabilitation in the community. So in light of what he pled to, the maximum is just not necessary now or at the time of the sentence to ensure his rehabilitative potential would be met. And just to return quickly to the difference between his family ties now and at the time, Mr. Wilkins became homeless when he was last arrested because of various residency issues, but now, he's in touch with his family. He has family members with whom he can live, and those things just won't be a problem, and this court has reduced sentences in the past, even where individuals didn't get even close to their maximum potential exposure, where there is family support, there is genuine remorse expressed, and so forth. And I do just want to say, this modification is small, relatively speaking, but it is hugely impactful for Mr. Wilkins. He will already have served more than 2 years, which is more than the minimum 1.5 that he's requesting. If this court were to reduce the sentence, he would still be subject to community supervision, but he would be able to reunite with his family sooner, to see his daughter, to start accessing those community-based services that probation acknowledged would be helpful to him. And just again, to underscore, Mr. Wilkins was living in a state of precarity at the time of this arrest. He was homeless. He was without services that he needed, including mental health treatment for anxiety disorder, and the confluence of these circumstances led him to make this regrettable choice. But he is in a better position now not to make that choice, and even at the time of sentencing, mitigation
Yes, that was before the sentencing court, but that in no way curtails this court's ability to change the sentence, militate in favor of this reduction.
Thank you, counsel. Thank you both.
Thank you.
Gilchrist versus Your First Home. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court, Kimberly Robleski for the defendant appellant. This appeal is based upon a straightforward application of CPLR 321C to the underlying facts. Simply put, while the underlying proceedings were occurring, appellant's prior attorney died on January 21st, 2016. This automatically triggered 321C's automatic
Does that,
stay.
when 321C is triggered, is that indefinite? Or does it somehow come to an end at some point?
Yes, so it is indefinite until the procedure, the notice, is served. And this was actually addressed a little bit more thoroughly in my brief. But the reason being here for this kind of indefinite nature of CPLR 321 is that there's a simple way to end the stay, and it is personally serving the party who lost their counsel with a notice to appoint another attorney.
But didn't your client ask for a motion for a continuance of trial? Didn't he send a letter and say, I want to represent myself? Can you please hold off on this? I'm getting out in January. And didn't the court then adjourn the case till September to give him an opportunity? And didn't he update his address with IRS and DMV, but not the court? Should we consider that?
Just twofold response to that, Your Honor. Of course, you should consider that. But in regards to the letter that he sent to the court, first, he was incarcerated during this time. He was aware of the proceedings, but he never received the requisite notice under 321. In regards to what
But
he said,
in that letter, did he say he knew that his attorney had passed away?
yes, but he was not served with the notice. And
Counsel, but he contacted the court while he was in jail, correct?
Yes, he did.
So he knew the case was going on, correct?
Yes, he
Now
was
he
aware.
gets out of jail. What does he do?
He goes on to his probationary period. He updates his
Does he
addresses.
contact the court?
He does not contact the court, but
So it's your position essentially that he wasn't required to do anything because he wasn't served with the notice, not that he could be found to be served with the notice because his address is not updated, correct?
not necessarily.
So how long does that go on? For years?
It can, Your Honor, it can. And the underlying case law is fairly clear. There can be windows of time where the stay is in effect, and it is only waived either when the party that lost their attorney either appears again in the action with a clear intention to proceed pro se.
Wasn't that June 16th when he
No.
sends the email and says, I want to be a part of this, I want to represent myself, please adjourn?
Specifically, Your Honor, just going to that letter, he actually states, he says, and I quote, being incarcerated, I have not had the opportunity to secure new counsel, nor do I have access to any records or documents in this case. While he does label the letter as a motion for a continuance, he was unrepresented at this time. He was incarcerated. He knew that the proceedings were continuing, but
Okay,
he
so
wanted
then he
to...
gets out, and 2 years passes, and nothing happens from your client. You're saying that even though he was aware of this case going on because he sent this letter in 2016, even though he was aware of it, that the case was going on, in 2 years, he did nothing.
Yes, because he was, well, whether or not he did anything, the burden is not on him under 321 to alert the court of his attorney's death and alert the court that he wants to proceed.
So
The
he
burden-
doesn't, but he doesn't have to alert anybody that he's changed his address. He just has to sit back and do nothing. Is that, I don't know if that's what our case law supports.
In regards to what the case law supports, it's not necessarily that he has to sit back and do nothing. It's just the burden is not on him to provide notice in order to waive this automatic stay. The automatic stay is in effect until either the notice
So
is...
if notice hypothetically had been provided to, I think the last address was the ex-wife's house, correct?
Yes.
So if notice had been provided there, you would say that that's sufficient notice?
If it was personally served, which is what the statute requires.
Oh, so how would he be found? Because he's not there anymore. How would he be, how?
Well, he was incarcerated and he sent a letter from the place where he was incarcerated. His address was there. He was required to update his records upon his release. So then his new address was on record with, as Your Honor stated, the IRS. It was on his
How about
probation
with the court?
records.
Did he notify the other side what his new address was?
No, he did not. But
His
again,
failure to appear did not have to do with his incarceration, right?
I apologize, I didn't hear the first
His
part.
failure to appear did not have to deal with his incarceration.
No, it did not have to do with his incarceration, but just to emphasize, again, Your Honors, the automatic stay is in place and it revolves around notice, not about knowledge of the underlying proceedings. Yes, he did not specifically reach out to the court to provide his new address, but that being said, the onus is on the respondent or on the court to provide notice, to provide another attorney, and 321 is meant to protect litigants that face the unexpected loss of counsel, not to be a sword to punish them for not following the proper procedure of which they may not be aware.
Thank you, counsel.
Thank you.
Good afternoon, Your Honor. First of all, just want to make an argument that was not in the brief, but there's an inconsistency and equivocality to what the appellant is arguing.
If it's not in your brief, are we considering that at this point?
It's just an overview that I'm throwing into the mix for 2 minutes or 30 seconds of my argument because it is a crucial, significant point. The appellant wanted 321 notice. Yet, the appellant also said, I never got any of the letters or notices that were sent to me. So even if there were a 321 notice sent to him, he wouldn't have gotten it. So
I think what counsel is arguing is that you had to personally serve him with that notice, not just put it in the mail and it arrives at the ex-wife's house.
And even there's a likelihood he would not have gotten it. It's
Counsel, you've been litigating this case for 13 years? Give or take?
It's a 10 or 11-year-old case, right. And the thing is, enforcing that kind of notice is, if he wouldn't have gotten notice, would be some kind of technicality or absurdity.
So why, in your view, why was 321C not violated?
Pardon me, Your Honor,
Why
why
was
it
this
not
provision not violated? Why was 321 not violated here?
Well, contrary to what my opponent says, there are several ways it can be waived. It can be waived by representation of an attorney. Defendant appellant had Ms. Lonstein representing him, talking to me, negotiating, discussing possibilities of a settlement. That was in April of 2017, or let me just get that date again. March of 2016, a year and 9 months before the default. Secondly, the CPLR 321 notice can be waived by pro se litigation. This man definitely litigated. He wrote to the court. That was in May or June of 2016.
He was asking for essentially an adjournment because he couldn't appear in court because of his circumstances, correct?
Opposing counsel called it a motion. It's activity. It's representing himself. It's trying to get a benefit. He got the adjournment.
Well, in that letter, did he state that he was now representing or then representing himself?
I don't know because I never got that letter at the time. I think that also would be a technicality. The main point is the activity and substance of what he's doing is litigation. He's pushing the case down the road and he's delaying it, which he did for 10 years.
Counsel, where does does an obligation fall on you to ascertain the correct address that the defendant resided once he left prison?
We did perform investigations going back to the very beginning. We had a tough time locating him for service. We talked to his criminal lawyers in the federal case. This appellant instructed his attorneys to not give us the address to obstruct service on
Would
him.
a DMV search have revealed his address?
I don't know if that was done. We had an address of some sort and sent mail to him there after the attorney died. So, I mean, the thing is, it was known. We did know he was in a prison in Pennsylvania. I mean, there are a few prisons there. It probably could have been Lewisburg, but there are a few other federal prisons in Pennsylvania that I know of, or at least one other one. So that was all kind of beside the point. We indulged him, man. Anytime something happened and he was in jail, we indulged him. We adjourned it, come back in a half year, come back in a year. There was a huge delay. So given that representation, given his pro se litigation, 321 has been waived. Plus, he's got actual notice. He knew his attorney died. He knew about court appearances. And then I sent letters and mail 3 times to the best address I had. One quick point, too. Appellant is wrong about citing the Meyer case and failing to raise the argument in the trial court and preserve it for appeal. That Meyer case was a case involving a pro se litigant. When appellant did file that order to show cause with the motion to vacate, he was represented at that time, so Meyer is not relevant. And furthermore, even Duandre Corp v. Golden Crust is a 2-paragraph decision which doesn't add anything and doesn't help us. And finally, to go on to that point about does this go on forever? No, the state does not go on forever. We cited matter of Cassini, quote, "It does not necessarily follow that the statutory stay of proceedings continued on ad infinitum." The road does not go on forever, or the stay does not go on forever. And he had 23 months.
Thank you, counsel.
You're welcome.
Thank you. Just 3 short points in rebuttal. In regards to the notice that was discussed by respondent, in his January 1st, or my apologies, June 1st, 2016 letter to the court, which he sent while he was incarcerated, he did indicate that he was presently incarcerated, which means that his address was not the address he lived at before he was incarcerated. And second,
But in those situations, the courts generally look to the last known address, which was his ex-wife's address, right? When someone's incarcerated, isn't that how we do it?
to be honest, I'm not entirely sure about when someone's incarcerated, but that was not his address. It was his ex-wife's address, and just
But, you know,
more important.
What I'm hearing from your adversary is that your client was essentially disappearing, trying to disappear, and not really give his address, and that's of concern because he certainly could have updated his address, and we wouldn't have had these issues.
Yes, I understand, Your Honor, but if
How do you respond to your friend's argument that he hired counsel to try to negotiate and thereby waived 321?
Yes, in regards to that, I believe he's referring to the email exchanges with a Miss Lonstein. If you go and read those email exchanges, which are attached to respondent's opposition to appellant's 5704 application, those emails, Ms. Lonstein, first of all, specifically states that she is not formally representing my client. She states that she is only discussing a possibility of settlement.
Does she ever say, by the way, my client's address is X, Y, and Z?
No, I don't believe so, Your Honor. I don't have those emails right in front of me. But again, she was only seeking out settlement at this point. She did not formally represent him. And just in regards to the waiver issue briefly, waiver.
So it's your position, until your client's address was discovered, nothing happens?
No, no, not necessarily. I mean, he could also have waived it via proceeding pro se, which he did not do. And again, it only takes.
So it's your position that nothing could happen until the plaintiff found precisely where your client was located?
Well,
Sounds
yes,
like
if he.
it sounds like gamesmanship.
Except that he can have someone, a lawyer, reach out to the other side to reach an agreement, but not represent him.
That lawyer, again, did not represent him formally in any capacity. She states that in her emails. And again, in regards to the address, his address was, it could be found. He filed it with the IRS. He had a driver's license, which is in the record, that states his address. He indicated in his letter to the court that he was going to a halfway house. I mean, he is the defendant in this case, and frankly, the burden under 321 is not on him. Just to briefly wrap up, in Moore v. Coven and Krause Esquires, which respondent says is not relevant here, it actually is entirely relevant, and they state specifically that as a general rule, unrepresented litigants should not be penalized for failing to alert a trial court to the existence of an automatic stay created for the very purpose of safeguarding them. Thank you. Unless the court has further questions.
Thank you. Thank you both. Innovative Securities.
Hi, good afternoon, Your Honors. My name is Stu Blander. I represent Prime with respect to the appeal of Prime's cross claims against.
We're starting with Prime. Is that how you want to start? I'd rather start with the plaintiffs first.
Oh, I'm sorry.
It's okay.
No, I apologize.
That's it.
May I please the court? Alvena Petrikov on behalf of Innovative Securities. Before I get into the argument, I just want to thank the panel for the patience and attention in this day with heavy packed calendar. This is a case that's factually complex with a lot of moving parts and asymmetrical.
But the law is not that complicated in this case. Would you agree? Facts are muddled.
I think to the extent the facts impact the application of the forum selection clause, that falls into the complexity.
So my question to you is this, do your causes of action, all of your causes of action, arise out of or in connection with the 2017 agreement?
They do not. The causes of action are related to margin calls that were made by the Cowen companies in March of 2020. And in 2019, as alleged in the complaint, the Innovative Securities moved its portfolio and assets from its accounts that were subject.
But the operative agreements that we're talking about, which govern all of these transactions, the 2017 agreement, the forum selection clause there talks about forum selection being in England, right? Because we're talking about actions arising out of these agreements or in breach of these agreements, however you want to say it. But regardless, there's a forum selection clause in there, right?
In the 2017 agreement, there's a forum selection clause, but the 2017 agreement does not envision commingling of Prime portfolio and Innovative.
Was there a termination of the 2017 agreement?
Innovative was asked to move its securities to a Prime account. Innovative requested by email.
I understand factually what you're saying, but what I'm asking you, because there's an operative agreement here, and we're trying to figure out what applies. So in this instance, was there ever a termination of the 2017 agreement?
There is an effective termination. The 2017 agreement.
The termination, there's a clause inside the 2017 agreement on how to terminate the agreement, right? Has to be in writing. Did that ever occur?
It says it can be terminated by email. This is in the record 176, section 16.2.
Okay, and you terminated it by email?
The email requesting transfer of the securities out of the Cowen account, Innovative account with Cowen, to Prime is effectively a termination. I don't think Cowen disputes that they...
So you're saying, in effect, there was a termination?
Yes.
Okay.
But the course of dealing was unchanged, right?
Well, if you look at the events, between the fall of 2019 and the margin calls, there was actually a difference because Prime used Innovative's portfolios for security of its own position. So unbeknownst to Innovative, the course of dealings, it appears to have changed. So that was the difference between the 2017 relationship and the change in structure after the 2019 shift to Prime as the prime broker on paper. And I think in the submissions by Mr. Katzenstein in the record, there is a clear acknowledgement that Prime Capital utilized Innovative excess capital. After the margin calls, the Cowen companies did not allow for weeks Innovative's cash and securities to be segregated. Again, this is something that's different from the 2017 arrangements. There was no commingling between Innovative.
If we were to find, hypothetically, that the 2017 agreement was still in effect, do you agree under those circumstances you would be subject to the forum selection clause, litigate in high courts of England?
I think it would require two agreements to be in effect at the same time. So I would respectfully submit that there cannot be two agreements governing the same relationship.
Okay.
2020.
Thank you. Prime, do you want to go first? I think that makes sense, and then yeah. So.
Well, first, on behalf of Prime, I think the case is controlled by a principle that this court has said many times, as well as the Court of Appeals, which is that when sophisticated parties who are counseled put down their understanding and agreement in a writing, such as the settlement agreement here, that writing should be enforced according to its terms. And respectfully, we think that the court below, in relying on the general choice of forum clause in section 13.2 of the settlement agreement, ignored the more specific provision in section 5.3. And I think if you read section 5.3, 5.31, it's clear that we Prime had a right to bring a cross-claim against Cowen.
Under what circumstances?
Under circumstances where Innovative, quote, commenced, close quote, a litigation.
Let me stop you there.
Sure.
So if we were to find, hypothetically, that the forum selection clause applies to the plaintiffs and the case has to be litigated in England, what impact does that have on your cross-claim?
The short answer is none. And the reason it's none is because, again, if you look at 5.3.1, the trigger for giving us the right to bring a cross-claim is the commencement of proceedings by Innovative. It doesn't say the proceedings have to be properly commenced. It doesn't say the case has to stay here.
If the proceedings are commenced in England, how do we then deal with your case here? Because essentially what you're saying is that there would be some kind of severance.
That's exactly what I'm saying. It's what I said in my brief, because that's the law. Severances happen every day of the week, where the plaintiff sues A and B, A cross-claims against B, the plaintiff's claims against A or B are dismissed. I forget my hypothetical. And the court severs, and I mean, the CPL and Professor Siegel say it.
Does the settlement say anything about severance or what would happen under those circumstances?
It says nothing about it, but what it does say is, if I could direct your honors to 5.3.1, it says nothing in this settlement agreement. Nothing. It doesn't say nothing in the paragraph. Nothing in the settlement agreement shall prevent, preclude, or in any way restrict any party from ... asserting any claim or cross-claim against another party in the Innovative proceedings. And it defines the Innovative proceedings It's sort of like you have to go back and forth. It defines the innovative proceedings as proceedings that are commenced by innovative against Cowan or my clients that relate to this entire mess.
As I read your friend's brief, you can harmonize 5.31 and 13.2 of the settlement agreement by viewing 5.31 as a reservation of your right, and then 13.2 addressing the form in which that right can be vindicated. Because 5.31 itself doesn't talk about the form in which the claim ultimately has to be heard. It talks about the right to assert it.
Well, if I could push back on that respectfully for two reasons. The first reason is, and again, you know, lawyers far smarter than me wrote this and negotiated this, but it says nothing in this settlement agreement, nothing. And that includes 13.2 as well. It doesn't say nothing in this subparagraph. That's point one.
But just in response to that point, aren't we required to look at the entire agreement? Or should we just focus on what you're asking us to focus on?
I want you to focus, Judge, on the words that we used. And the words here are nothing in this settlement agreement. And moreover, it says, the next paragraph, it says, for avoidance of doubt, any claim or cross-claim that any party can assert against any other party in connection with the innovative proceedings is expressly reserved and preserved without limitation. It's pretty broad language. That's point one. The second point is, hardwired into the entire concept of a cross-claim is, under both the CPLR as well as under the federal rules, is that you bring the cross-claim in the proceeding where the main action has been filed. That's sort of what, I mean, we all learned this the first year in civil procedure. That's what a cross-claim means. So their position is a little bit illogical. What they're saying is, to the extent Innovative's case stays here, and they get to sue us, and we have a claim for contribution and indemnification, which is one of our claims in addition to affirmative claims, we have to go to London or wherever to bring that, quote, cross-claim, which they defined as a cross-claim. That makes absolutely no sense to me. And then just very, very briefly, so I mean, I think that you know, we sort of have much the better of the argument if you look at the language of the agreement. They could have drafted it if the case is dismissed, you go elsewhere, but they didn't.
Got it. You already made that point.
Okay, thank you.
Good afternoon. May it please the court. I'm Scott Balber on behalf of the Cowan respondents. Let me first address the question of termination of the agreements with Innovative. Putting aside that no termination happened, the agreements are all clear.
What about that email she talks about?
There's nothing in the email that even refers to termination, suggests termination, uses the word termination or any synonym for termination. But even if it did, the agreements are crystal clear on their face that the form selection clause survives termination. So even if they were terminated, we don't belong here because the form selection clause mandates that the case be brought in the courts of England. Moving on to Mr. Blander's argument, he notes that lawyers far smarter than him negotiated the agreement. I'm not going to comment on that. What I will say is they were English lawyers. And the agreement, the settlement agreement that contains the cross-claim language is governed by English law. And neither I, nor Mr. Blander, nor respectfully this court, knows what a cross-claim is under English law. But what's clear about that settlement agreement is that it says, like all the other agreements between the parties, it must be brought in the courts of the United Kingdom, not the courts of New York. There's nothing remotely inconsistent about sections 5.31 and 13.2. The fact that a cross-claim can be brought under English law is not inconsistent with 13.2, which mandates that it be brought in the courts of
How do you
England.
respond to the argument that plaintiff brings the action here? Okay, maybe the action was misfiled here and it goes to England, but under our law now, a procedure, that there can be essentially a severance and we can continue to litigate in New York.
Except for the fact that Prime agreed in 3 different agreements that any disputes between the parties would be adjudicated in the courts of England. So nothing about the New York procedural mechanism of severance obviates.
Wasn't one of those agreements he was going to litigate in Bermuda, I think the 2019 agreement? Am I mistaken about that? Was it always England? Was it
no,
always
that's
England?
not right, Your Honor.
Okay.
But does a choice of law provision always carry with it both the substantive and procedural law of the desired form, or do we presume that it's the substantive law only and we apply our procedural law?
So good question. The short answer is the agreement, the settlement agreement, makes no distinction between substantive or procedural law. And again, I'm not qualified to opine on whether English law agreements require import of both the substantive provisions of English law or substantive and procedural. It's, again, an English law governed document, and none of us respectfully know what English law says about the extent to which their procedural laws should be controlling in an English law governed agreement.
I mean, I guess the answer is that it's substantive law for the purpose of defining the terms in the contract, because plainly we have to apply English law, substantive law. I think there's some limitations on that with the procedural law, but from a substantive standpoint, we're taking presumably the whole body of English law.
I think that's precisely right. And again, step 1 is the forum selection clause mandates that the English court consider the question. They would then apply English law to ascertain whether or not the procedural or substantive provisions are applicable to this dispute.
Now, going back to the plaintiff's core arguments, they're obviously trying to move away from the 2017 argument, saying that their causes of action really relate to what happened years later and have nothing to do with the 2017 agreement. How do you respond to that with specificity?
There's no such thing as years later. Let me walk you through the 5 causes of action, which I think Your Honor alluded to earlier, all of which relate to the only agreements between the parties, between Cowen and Innovative, which is the 2017 agreements. Count 1 seeks a declaration that those agreements are not enforceable. I don't know how we could even be debating the question of whether or not the 2017 agreement mandates choice of the English forum when their first cause of action seeks to invalidate that very agreement. Count 2 claims that we fraudulently induced them to enter into, you guessed it, that agreement. Count 3, that we breached our fiduciary duty. In count 4, we were negligently supervising with regard to our duties as prime broker under that agreement. Number 5, that we were unjustly enriched because of monies we received as prime broker under the agreement.
To the extent, well, go ahead.
No.
To the extent we were to agree that dismissal of some or all of the causes of action ought to be premised on the fact that the appropriate form is England, why should the dismissal be with prejudice? Doesn't prejudice normally connote that it's on the merits and that it will have the disposition will carry with it certain res judicata and collateral estoppel effects?
So I believe that the dismissal with prejudice would apply to actions brought in this court. It would not. It would be dismissal with prejudice vis-a-vis the improper forum, and that would not, in my view, again, I'm not an English lawyer, preclude the case from being refiled in the United Kingdom pursuant to the law of England.
So why shouldn't, under the circumstances, if we agree, say that the dismissal is without prejudice to make sure that it has no impact if the case is going to England, that the English courts are clear what we are saying?
It would be well above my pay grade to suggest what this court should say, but I think with prejudice vis-a-vis this court, and with prejudice meaning no ability to amend and reassert in New York, with whatever caveats the court deemed appropriate to allow for a substantive refiling elsewhere.
Thank you.
Thank you.
No, plaintiff? And then, just sequentially, it works for me, Counsel. Go ahead.
Your Honor,
So I want you to address what your adversary
yes,
point.
I would like to address what Mr. Barber said about termination. I think his argument reinforces the point that this is a factual issue. We made an allegation in the complaint that this was replaced, whether it was terminated, whether it was triggered by them, actually, which comes from Prime's allegations and affidavits, or...
But I think, and I'm sorry to cut you off, but what your adversary points out is that your causes of action are clearly related to the 2017 agreements.
I don't think so. I'm looking at our causes of action, and they don't identify specifically the 2017 agreement. I disagree.
What agreement? What agreement could it?
I think one is fraud, that we're fraudulently induced to enter into a new arrangement in 2019. One is breach of fiduciary duty, because Cowen has certain responsibilities.
Is inside the agreement that you're saying is terminated, wasn't there a clause that said that they owed you no fiduciary duty? Or that they weren't fiduciaries?
Our argument is this agreement does not apply. They acted as a
So no agreement applies?
2017 agreement doesn't apply.
So then what's the next agreement that applies to support your argument?
There is no written agreement governing the relationship between Cowen and Innovative as of 2019. The relationship is with...
Hold on, because you're saying that it was terminated through their actions, not necessarily by written notice?
It was terminated based on the consent of both parties.
And where is that in the record? That happened?
There is an allegation in the complaint that...
No, in the record. What do you have to support that?
There is no email in the record, but there is an allegation in the complaint that we were asked to transfer our securities and portfolio. And I think at the motion to dismiss stage, we're entitled to the most favorable inference in our favor.
Thank you, Counsel.
Two quick points with respect to Prime's appeal that I just want to briefly address Obex and Katzenstina's respondents. One, I don't think you have to have a knowledge of English law. I think you have to have a knowledge of the English language to figure out what 5.3.1 says. And point number two, with respect to maybe having to go to London to cross-claim, what the clause says is, it says asserting a cross-claim, quote, in the innovative proceedings. And for better or worse, the innovative proceedings are at 60 Center Street, they're not in London.
But if they were moved to London, if we were to agree with the respondent here, then what?
Well, first of all, that assumes, first of all, that innovative is going to proceed in London. I have no idea if they're going to do that. And second of all, the trigger, from my view of the world, is, quote, the commencement, not what happens after. With respect to...
Well, would that lead to the absurdity that the underlying claims that form the basis of the innovative action would be addressed in a forum in England, and the cross claims would be addressed in a New York State Supreme Court?
Well, first of all, the cross claims, there's only one cross claim for contribution and indemnification. The other cross claims are for affirmative relief, i.e. money, to Prime against Cowen. So there's nothing anomalous about that. And the second thing is, even if, we think it's anomalous, this is what's written, and the Court of Appeals has said 100 times, just because, judges after the fact would think something is unusual or strange, they sort of have to enforce as written, which I think it's clear here. With respect to, separate and apart from the forum issues that counsel discussed, the reason there's no claim against my clients by Innovative is twofold. First, as the judge correctly said below, this part was correct, there's absolutely no causation, because by their own admission in the complaint, and today, as counsel said, quote, the margin calls were made by the Cowen companies. The record is undisputed. My clients were yelling and screaming, don't do the margin calls. So the injury, the proximate cause, was nothing we did. The second thing is, I see just, but substantively, The claim is that their assets were not segregated and they're available as collateral for other obligations. The problem with that is on page 42 of the record is the so-called cross-collateralization provision, which specifically authorizes it. So you can't be defrauded, as this court has said 1,000 times, when you are presented with a document and you could have read it, and you didn't read it, or did read it, or ignored it, and claim that there were other oral representations that were inconsistent with it. And since that's the basis of their claims, they have no claims. Thank you.
Thank you. Thank you all.
May I respond to the OBEX?
No. People versus Johnson. You may proceed, counsel.
Good afternoon. Benjamin Rutkenbecker, Center for Appellate Litigation, on behalf of Austin Johnson. The trial court erroneously denied Mr. Johnson's request for an intoxication charge. The undisputed evidence in this case was that Mr. Johnson was highly intoxicated at
Was there any testimony on the record specifically, not vaguely, but specifically about how many drinks that he consumed, the time period under which he consumed these drinks?
So the only evidence of that, Your Honor, the complainant testified that the two of them were drinking the night before to the extent that she, had her faculties but was still feeling it the morning after. Of course, he goes out that night, returns in the wee hours of the morning, and she says, emphasizes the real and real drunk 7 times, real bad, really sloppy, rambling incoherently. And most importantly, Your Honor, about those factors, it is true the cases have identified those factors as relevant to an intoxication charge, but they're relevant insofar as they help to shed light on the operative question. And that, of course, is the accused's intent at the time of the crime.
I know that you rely on the People v. Velcher case.
Yes, Your Honor.
But in that case, there was a little bit more evidence presented by, and in fact, there was evidence presented by the defendant, and in this case, we don't have that. And we all know that he doesn't have to present a defense, but in the Velcher case, there was. Why should we draw that parallel then with that particular this distinguishing factor?
Well, I think the key, Your Honor, as you noted, the defense doesn't have to present evidence. I do understand the question, but I think the key is taking all the evidence in the light most favorable to the defense, as with any defense. And here, I honestly cannot think of stronger evidence on the question, the operative question, than the complainant, who knew Mr. Johnson very well, both drunk and sober. I mean, this was unfortunately a highly toxic alcohol-fueled.
Even if I were to accept what you're saying,
sure.
Why wouldn't harmless error apply in this circumstance? Because what the testimony was that the defendant held EF's head down and ignored her plea to stop. Doesn't that show an intent to commit the act?
So to the extent what Your Honor is saying is that there was strong evidence of intent here, there was also very strong evidence of intoxication.
I'm asking you, why is it not harmless error?
Sure, Your Honor. So I think it's important to look at what the jury was left with. This was Mr. Johnson's most viable defense, and it wasn't just a trial defense. This is what the first things he said about the incident may well be the reason why he actually elected to go to trial. He didn't remember the incident. And the jury,
But that's not what defense argued to the jury. That's a different theory. To the jury, in summation, he argued it was consensual, and the complainant witness is just accusing him because she's angry and abandoned. Nothing about intoxication.
Because the charge had been denied, Your Honor. And that's exactly the point. That was...
But there was no, come on, but there was evidence.
Why not question the complainant when she said he was real drunk 7 times? Why not say how many drinks did he have? Do you know how many drinks did he have? Do you know if he had 10 bottles of Hennessy?
So the evidence, I can't see what else is required. First of all, the evidence did establish that he was gone. I don't think she would have been the person to know how much she drank, but she clearly, it doesn't get much clearer than her saying, again, on the question of his intoxication at the state of the time. She knows him very well. He
Does
is
the fact that he cleans up afterwards indicate any consciousness of guilt or intent, or how should we view that? Because that was something that he in fact remembered.
I don't think that's relevant to the inquiry here. The parts of the prosecution's brief that discuss that essentially read like summation argument and marshal that evidence. It's ambiguous.
It was part of the trial, right? That came out during
Of course that came out. I'm not disputing any of the facts Your Honors have stated. What I'm saying is that we take the evidence in the light most favorable to the defendant to see whether the jury should be weighing all this evidence. Counsel was not required to elicit any more evidence than from the complainant who testified to Mr. Johnson's state of mind. Of course, in summation, he could not argue anything about intoxication and was forced to challenge the complainant's credibility, leaving the jury no choice really but to, if they were to accept her testimony, and she was very sympathetic, of course, then they had to convict him because there was no other option.
This was a brutal crime, counsel.
Understood, Your Honor.
Thank you. You may proceed.
Good afternoon. May it please the court, Assistant District Attorney Max Bernstein for the people.
I mean, counsel, the complaining witness herself, who is in a good position to know the defendant when he is in fact intoxicated, seems to be the basis of their relationship. She testified to her perception of him, and it was that 7 times really, really drunk. Why isn't that sufficient to get the charge for intoxication?
So I have 2 answers to that, Your Honor. So the first is her testimony was, I think, more equivocal than defense counsel's representations make it out to be. There was also testimony in the record, and I point Your Honors to, I think it's 21 to 23 of the trial transcript, where the victim acknowledged that defendant was also steady on his feet, that he responded cogently to the things she said to him. I believe counsel used the phrase rambling incoherently. That's not in the trial record. She does not describe him as rambling incoherently. She does suggest that he's sloppy and belligerent, and does say also that he he's extra expressive with his words, but she does say that he's cogent, that he's responsive to what she says, that he's steady on his feet. And I think the bigger point to Justice Singh's question before is that the evidence of intent was so profoundly overwhelming here that there wasn't any, and again, Justice Carroll properly said it directly to Perry's standard here, there was no way that there was not sufficient evidence in the record for a reasonable person to doubt defendant's intent based on the record of his intoxication. So I would say
So
both.
are you arguing harmless error, that the error, if it was harmless under the circumstances?
If there was one, surely it was
Or the
harmless.
evidence was overwhelming as to intent?
Yes, and I would say certainly it was harmless, but deeper than that, I think Justice Carroll made a reasonable call on the basis of the evidence of intent to say that there was no basis upon which someone could doubt the intent, and that is the standard, based on the evidence of intoxication that was put into the record. So the arguments do sort of meld together a little bit between harmlessness and sort of the first.
Counsel, what do you have to say as to the people's late disclosure of the property voucher, the phone? What do you have to say about that?
That was emphatically, clearly I would say not the voucher itself, as we mentioned in a footnote, but clearly there was an obligation under 245-20M to provide a list as to what property was missing, was taken at arrest. And manifestly, we do not contest that that list was not provided, and no other acknowledgement of the phone taken was provided in any sense. So without question, there was a technical discovery violation there, without question.
So there should have been an adverse inference charge?
Well, as we explained in our brief, an adverse inference charge for discovery violation only lies where there's a showing of prejudice. And we contend here there was not even a scintilla of a showing of prejudice by opposing counsel at any point, even on appeal when they've had opportunities to sort of proffer hypothetical explanations for what the prejudice might have been. They still have not offered any accounting of what it was that might have been on the phone. And I want to say,
Especially anything exculpatory.
anything of any kind, Your Honor, but certainly anything exculpatory. And again, this is defendant's phone. There might be contexts where it would be unreasonable for us to ask defendant to make any sort of offer of proof about how they were prejudiced because, of course, evidence was lost and it would be unfair to ask them to speculate about what that evidence was. But this was defendant's phone. These were defendant's texts that he allegedly thinks might have been helpful to him. These were defendant's photos that he doesn't know exist but thinks perhaps might have been helpful. These were defendant's phone calls that he made. It is not unreasonable to say, if you're going to claim prejudice here, show us somehow what that prejudice might perhaps have consisted of. And at no point did they.
The phone was sold, right?
Yes.
The phone is gone. So
Yes.
we can't even get the phone and check.
We cannot. The phone's gone.
Was that where proper procedures followed with that?
Within the NYPD? That is the NYPD's safekeeping policy. I can't tell Your Honor whether or not that continues to be their safekeeping policy, but the basic, I think, thought behind the policy is if property is vouchered as safekeeping and not as arrest evidence, it's basically just being held for the benefit of defendant whenever defendant's available to come pick it up, or when a member of their family perhaps is available to come pick it up. And the NYPD can't be permanently responsible for people's property, so they had an under 80-day window that lapsed and the phone was auctioned off. But again, that was predicated on the fact that the phone was not evidence in the case at all and never was believed to be evidence by anybody in the case. And defense counsel's suggestion that it might have been was supported again by not even hypothetical gesturing at what might have been on the phone that would have made it evidence in the case. So I would say there was no prejudice and therefore no reason for an adverse inference charge. But again, harmlessness. I mean, as Your Honor said, this is a horrifying case. It is difficult to imagine what an what could have popped into the jury's head in response to an adverse inference charge about an unknown phone with unknown contents that would have made them doubt intent in this case, or anything else that was necessary to prove out the charges. The people's evidence was powerful, and I would note the jury deliberated for less than 2 hours. They asked no questions. This was not a closed case. So it stands to reason that harmlessness.
If there had been an intoxication charge.
Well, I just want to, on the intoxication charge, thank you for the reminder, Judge. I just want to point out, it wasn't just at summation that they failed to raise the issue of intoxication. Much more importantly, at opening statements, they failed to raise any discussion of intoxication at all. And on the record, as they went through, straight through, this is before any discussion of the charging conference, before any question about whether intoxication was actually going to be provided to the jury, defense counsel did nothing at all to develop the record with respect to intoxication. And in fact, if you look at page 92 of the trial record, the one question defense counsel asked during the entire trial proceedings about whether or not defendant was actually intoxicated sought to cast doubt on the victim's description of defendant's intoxication. The question was, isn't it true that you told the arresting officer that you didn't even realize the defendant was drunk until he was already assaulting you? So clearly, defendant did not carry their burden in order to establish any question in the record that would have warranted an intoxication charge here. Thank you.
As to the merits of the intoxication charge, the prosecution really can't point to a single case in which such compelling evidence of the state of mind, of the actual fact of intoxication, was not sufficient to warrant a charge. The prosecution would essentially have the judge sit as a matter of law, make this finding of intent, and take it out of the hands of the jury, and that is not the law. As to harm, defense counsel did not need to telegraph his defense, but to the extent that the prosecution is suggesting this comes out of nowhere. Again, this was what the first things Mr. Johnson said about the incident was that he was wasted, he didn't remember it. This was not just a speculative, made-up defense, and the case would have been different. There were really no options without the intoxication defense but to contradict the complainant's testimony and really go after her credibility. That was not an effective trial strategy. I don't think it ever really would have been. Her testimony was very compelling, and the jury was entitled to have another option to consider, again, the really severe evidence of intoxication at the precise moments of this incident and how that operated on Mr. Johnson's intent.
Isn't it a little contradictory to either, I don't know what happened, I was so drunk, and she consented? Isn't it, you have to pick one or the other?
I don't think so, Your Honor. I mean, I would suggest to the extent that's true that intoxication was a much stronger defense here than questioning the complainant's credibility. I mean, she was I do not dispute any of the characterizations of what happened here, and she was a very compelling witness. That would have proven, that was his most viable defense that was taken away from him. Thank you, Your Honors.
Thank you. Thank you both. Ocean Trails. So we're going to hear first from the plaintiffs. You may proceed, counsel.
Thank you, Your Honor. Andrew Dunlap from Selendi Gay on behalf of the plaintiffs. I'd like to start with our good faith claim, and we submit that the motion court erred in denying this claim, dismissing this claim at the pleading stage on the basis that it duplicated our contract claim. It could not duplicate our contract claim because we bring it in the alternative to that claim, assuming that they are right on the contract. But even if they are right on the contract and didn't breach the contract, they can still breach the implied covenant.
So, but let's just go back to it. So it's the up-tiering transaction which you're complaining about it. The contract either allows for it or doesn't allow for it, correct? So if they're right, it doesn't allow for it, how do you then get, on that particular claim, a implied covenant cause of action?
We get there under this court's precedents in AEA and Credit Agricole. In those cases, this court held that minority holders can state an implied covenant claim against a debtor and majority holders, even if they don't breach the contract, if they perform the contract in a way to deny the minority the benefit of the bargain, specifically if they act to fundamentally change the nature of the asset that's being held under the credit
But if the agreement allows them to do it, then how is that a breach of an implied covenant?
Because the breach of implied covenant says that even if you're allowed to take an action as a general matter in the abstract, you can't take that action in a way which denies your counterparty the benefit of the bargain.
But counsel, as I understand it, the contract was written to allow a majority of the lenders to agree to a certain action. And while you remained equal, you didn't lose anything. You didn't gain anything, which is maybe what you're upset about, but you didn't lose anything.
To the contrary, Your Honor, we lost a great deal. What they effectively did here was turn first and second lien debt into fourth and fifth lien debt, subordinated under $860 million of new debt, with all our standard credit protections stripped away, at the same time that they took the defendant lender's debt, turned that into senior debt, so it's less risky. They give them a higher interest rate, even though it's less risky, and they buy it off at a premium, which drains value out of the company.
And what in the contract prevented them from taking that action?
Multiple things in the contract, Your Honor, and that's the subject of the cross appeal. The things in the contract that prevented them were there were provisions that say you can't issue new debt unless it is junior or pari passu to the existing debt, and if lenders
As to
receive
the debt within your own tranche.
within your own tranche,
right?
That's correct.
Now, did anything they did in the course of their up-tiering agreement do any violence to you receiving pro rata share within your tranche?
We say effectively yes. So what you started with were plaintiffs and defendant lenders were all first and second lien lenders, some in the first, some in the second. And what happened was the defendant lenders were given a bunch of goodies. They were able to turn their first and second lien debt into this new senior debt where they got a new higher interest rate even though the debt is less risky. Whereas our first and second lien debt, that's what it's still called, now effectively becomes fourth and fifth lien debt. No increased interest rate for the risk, and all our credit protections are stripped away. That, we say, denies us the benefit of the bargain in the good faith claim, because what any reasonable holder would have expected is even if they could engage in non-pro rata transactions, even if they could buy back debt in certain ways, they couldn't do it in a way that came to this result, where you have a fundamentally different asset at the end of the transaction than you did at the beginning. That's what AEA and Credit Agricole says. In their implied covenant claims were sustained because the defendants conspired to turn secured debt into unsecured debt. It's very similar here. The defendants conspired to turn our first and second lien debt into fourth and fifth lien debt.
How is it a conspiracy if the contract plainly allows them to do it?
First of all, now there's a cross appeal on terms of what the contract actually allows, and
I think part of what you need to understand from at least the sense I'm getting is, and I know from my perspective, one of the bedrock principles, whatever sort of flowery language sometimes coats the cause of action for breach of the covenant of good faith, one of the bedrock principles is that whatever covenant that is being propounded by the plaintiff cannot contradict the terms of the contract itself. And so if something if there would be an inconsistency between the promise that you're seeking to impose by virtue of the covenant, there's an inconsistency between that and the plain language of the contract, then we can't recognize the promise that you're seeking to interject by virtue of the covenant.
Well, we disagree, Your Honor, because under the Court of Appeals precedents, under AEA, under Credit Agricole, even if they have the discretion to do something under the contract, for example, issue new debt, or buy back debt. We think it's an exchange, but they call it a purchase debt. They can't do that in a way that denies us the benefit of the bargain. And the benefit of the bargain for us is all holders in the same tranche are going to share pro rata in the benefits of that tranche. Whereas here, one group of lenders was elevated, another group was subordinated. That is the essence of denying us the fruits. And it's not just the result that was problematic here, it was how they went about doing it. Any reasonable holder would understand that when holders amend a contract, they have to live by the terms of the amendment that they approve. The defendant lenders didn't do that here. They gutted the contract, stripped rights away from the first and second lien holders, then immediately swapped that for other debt. So they didn't have to live by the terms of the
Well, I
contract.
guess this would
that they
relate
just
to your
eviscerated.
friend's argument that they did not do they did not amend or modify or alter the text of the underlying agreement. There may be some a potent indirect effect by their new agreement, but they did not modify, alter, or amend the text of the original agreement.
No, they did amend the text of the original agreement. They stripped away a bunch of covenants that would have prevented them from issuing new debt and doing it on the basis that they did. So what we also just want to point out that the touchstone of the covenant is what parties would reasonably expect the contract terms to mean. And we say at this term, the only way the court could have dismissed this claim as a matter of law is to say on the face of the contract that any reasonable holder would understand that the contract allowed this to happen. But we know that is not reality. This contract was signed in 2018. At that point, these up-tiering transactions had barely occurred at all. They certainly were not commonplace. They didn't start becoming more common until a couple of years later. And even at the time of the transaction, as soon as it went down, the value of the first lien debt plummeted from 62.25 to 35.25. That means that the market, which is made up of reasonable holders, did not understand that up-tiering transactions like this were possible. Now, we will prove this if you revive these claims. We will put on the testimony of traders and of experts showing what reasonable holders would have understood these provisions to mean and that the defendant lenders breached those expectations. I'd like to, if I could, just briefly address our tortious interference claims, which the court below dismissed based on the affirmative defense of the economic interest doctrine. And that doctrine would require Searchlight and Credit Suisse to show, as a matter of law, on the face of the pleadings, with all inferences in our favor, that they acted to benefit their interest in Mitel. Not just that they have a general interest in Mitel, but that the specific acts complained of furthered that interest. And we allege the contrary. What we allege is that Searchlight, which is a private equity firm, acquires lots of different companies, and it does it through loans, which it gets primarily from the same repeat players, many of whom are the defendant lenders.
But let me ask you this. Why wouldn't Searchlight and Credit Suisse have an economic interest in ensuring that Middle, for example, gets more capital, buys another company, pays down debt?
Again, they have a general interest in Mitel, but they weren't furthering that interest in what they did here. So what happened was Searchlight directed Mitel to enter into this partnership with Ring Central. As part of that, they sold some intellectual property to Ring Central, and in part for $300 million worth of Ring Central stock. And Searchlight told the holders, this is such a great deal, we're going to be able to pay off all your loans early, which is an extra benefit. You get the same interest only on an earlier time frame. But they failed to have Mitel hedge their exposure to that stock, and that stock dropped by 80% over the next year. So Mitel lost $240 million. What this meant was that the holders weren't going to get paid off early anymore, and their loans, which had been trading above par at 107 cents on the dollar, were now trading at 66 cents. So those lenders were upset, and that was a problem for Searchlight, which depended on them for repeat business. That's why they had Mitel enter into this deal, and as part of the deal, what they did is they exchanged the defendant lender's first and second lien debt for this new debt at a massive premium to the market. If you do the math, they overpaid by $185 million. They extracted $185 million of value out of Mitel and gave it away to the defendant lenders. That didn't further Mitel's interest, that hurt Mitel. And that didn't further anyone's investment in Mitel. All it did was further their relationships with the defendant lenders to partially make up for the debacle on Ring Central.
Thank you, counsel. Who are you, sir?
Good afternoon, Your Honors. Emil Kleinhaus, Wachtell, Lipton, Rosen, and Katz. I represent the Mitel respondents and cross-appellants. Subject to the court's questions, I will start with the implied covenant claim, and then I will turn to part of the cross-appeal. I expect my colleague will continue with the cross-appeal. The market for syndicated loans in New York is incredibly robust. The parties are extremely sophisticated. Parties in that market can easily draft and negotiate provisions that require unanimous consent for new senior loans. They can easily draft and negotiate provisions that
Under the
prevent.
circumstances here, why isn't plaintiff correct? That essentially maybe you are permitted to do this up-tiering transaction, but the net result is a lot of loss to the value of their investment.
Your Honor, loss to the value of their investment does not create a cause of action. The plaintiffs here and all the lenders, cutting through all the complexity, agreed to basically two things. They agreed that a lender majority, and Mitel could amend the credit agreement to allow for new senior debt. That's totally plain from Section 6.01 and 9.08. And they agreed that Mitel and lenders could engage in non-pro rata purchase transactions. So counsel made the comment that they couldn't have reasonably expected this transaction, but this transaction is what they agreed to. There was a majority that amended the agreements to allow for new senior debt, and then Mitel.
Sorry, are you conceding that there was an amendment?
There were amendments exactly as allowed by Section 9.08 and Section 6.01 to allow for new senior debt, and then Mitel used some of the new senior debt to engage in non-pro rata purchases.
Was the procurement of the non-pro rata a discretionary act under the contract?
It
Under the
was
initial agreement.
The agreement expressly permitted it. Section 9.04I said, notwithstanding anything else, it's an override provision. At any time, so it's broad, Mitel can engage in non-pro rata.
So Mitel had discretion under that provision to procure.
Mitel had the right to do it. And I heard counsel's argument about discretion. I think that goes back to the Dalton case from the Court of Appeals. Now, the Dalton case, there was a test administration service that told people who were accused of cheating, you can submit evidence to us that we're wrong. And then apparently they didn't consider the evidence, and the Court of Appeals says, look, if you say you're going to accept appeals, you got to consider the evidence. That's a very far cry from our situation here, where you have super sophisticated parties that are given a contractual entitlement to do something. The Court of Appeals decision in Irk v. Moran, which involved an approval right to a real estate transaction where the contract said the transaction is subject to approval, is much more on point. I mean, as in Irk v. Moran, in this situation, the contract said Mitel and participating lenders, Mitel and the majority lenders can amend. They had a contractual entitlement. It said—
Counsel, I'm going to just ask you to, because your adversary made a lot of references to the AEA middle market case, which reaffirmed, I guess, the Credit Agricole case. Do you want to talk about that?
I do. Those cases are extremely different. What happened in AEA and Credit Agricole is you had express contractual provision saying that if there's an exercise of remedies through a foreclosure sale or a credit bid, and the administrative agent is going to act to exercise remedies, that action has to be on behalf of all lenders. That's the language in that contract. There has to be a pro rata distribution based on that foreclosure sale or credit bid. So what the defendants did in that case, allegedly, is they conducted a foreclosure, they conducted a credit bid, but then notwithstanding the express categorical unqualified requirement to have pro rata distribution on behalf of all lenders, they orchestrated the transaction so that a subset of the lenders, the majority lenders, got all the benefit despite the categorical requirement pro rata treatment. This case is extremely different. In some ways, it's the opposite, because Section 9.04I expressly permits, in broad language, at any time, non-pro rata transactions. And Section 9.08 permits majority amendments subject to very specific limitations. And to the point about reasonable expectations, whereas in AEA or Credit Agricole, there was at least an argument that there could be a reasonable expectation of not having a transaction where the value was diverted to certain lenders over others. Here, in contrast, there are provisions that specifically allowed the non-pro rata treatment. And to the extent there are exceptions to the majority amendment requirement, those exceptions are laid out in excruciating detail. And we don't believe that those were violated, but that's a separate cause of action. But there's no room whatsoever for the implied covenant when you have this excruciating detail as to what amendments are permitted or not. And I'll just briefly talk about a couple of points on the cross appeal, because there was the denial of a motion to dismiss from what are known as the sacred rights provisions, 100% consent. And one provision, which is 9.08b1, says that each lender adversely affected thereby has to consent to a change in economic terms.
So did the subordination of plaintiff's loan affect the plaintiffs either directly or indirectly?
Well, so let me break down each provision in answering that question. 908b1 says that you need a reduction in a decrease in principal or a change in an interest rate, and only the lenders who are directly adversely affected thereby, which by its plain meaning, by that reduction. So the intent of that provision, and there's a case called Murray Energy which says this plainly, is to require the parties whose economic terms are changed, not some indirect effect, some arguable market effect, but actual change to the terms. And as to 9.08b4, likewise, it's very carefully drafted. What it requires is an amendment to section 7.02 or section 2.18c. The words have to be amended. Those words weren't amended. Not only were the words of the provisions not amended, but the defined terms were not amended. The term intercreditor agreement was not amended. And that's very different from a case that the plaintiffs cite, the Trimark case. Exactly the same. And entering into a new intercreditor agreement was not an amendment of section 702 or 2.18c. The category of intercreditor agreements was already predefined. It didn't have to change. It's the opposite of an amendment. It's fitting the new agreement into the existing 702 and 2.18c. So there may have been an indirect market effect, that's alleged, but in terms of the actual kind of change that's required for a violation of this agreement, namely a reduction of their principal or an amendment to these particular terms, that did not happen, and therefore we respectfully submit that those causes, the causes of action based on violation of those sacred rights, should not have been, they should have been dismissed. So we would seek to, that dismissal or non-dismissal be reversed. Lastly, Your Honor, there's a cause of action that turns on whether or not this was a purchase, and we would submit, and I'll let my colleague continue on this, that it certainly was a purchase. There's both, as a matter of plain language.
Let him, don't steal his thunder.
Point taken, Your Honor.
Good afternoon, Your Honors, and may it please the court. My name is Elliot Moskowitz. I'm with the law firm of Davis, Polk & Wardwell, and I represent the defendants, respondents, appellants, participating lenders. Your Honor, my clients, I think there's no dispute, held more than 50% of the debt at issue in the challenge transaction. With respect to the good faith and fair dealing claim that's lodged against my clients, we adopt and incorporate in full Mitel's arguments. Everything that counsel said with respect to Mitel applies with respect, at least as much with respect to my clients. And so if that would be a successful defense, and the trial court, the lower court reached a correct decision with respect to the good faith and fair dealing claim against both of us. With respect to the contract claims that the lower court failed to dismiss, I just want to speak about that briefly. First of all, there's no dispute, I think, that there are sophisticated parties on both sides of the transaction. In fact, Your Honors will see cited in the papers the CERTA case over and over again. And in fact, in the wake of that case, it's another one of these up-tiering transactions. In the wake of that case, lenders have bargained for, you'll see it in the literature, what are called anti-CERTA provisions to guard against contractual provisions being invoked that way in the future. The same could have been done here by the sophisticated parties on both sides.
I think what your adversary was arguing is that this was something that was really not known at that time.
Well, I don't see why that. There's no reason why it couldn't have been known. This is not some provision of the contract that's absent. This is actually an invocation of an express right in the contract. I just want to note in particular that the right that we're talking about is in section 9.04 I, and that is not a provision, or the exception that we're talking about in that provision, that is not a provision that was amended by the transaction. That exists today as it in the amended agreement as it existed in the original agreement. The same is true with respect to 2.18C. That's the pro rata sharing provision. That was not amended by the amendments, the amended transaction. That remains as it was. So let me speak for a moment just about if I may, Your Honor, about 9.04I, which is the purchase exception that the company invoked in undertaking the transaction with my clients. I think their entire contention is that a purchase needs to be done with cash. It cannot be done with respect to debt. We would submit, Your Honors, that there's no basis for that. We cite in our briefs Legion case law that talks about purchase being defined. You can start with Black's Law Dictionary, Webster's, and then also many cases, including a Court of Appeals case, Justinian, all of which say that a purchase can be both cash, money, and also other things, and including debt. And here we have a purchase that was made with debt. Last point I'll make, Your Honors, is that you can actually look to case law that was in this particular context where this argument was raised by parties in the same situation, and other courts, I'm not going to tell you it's a Court of Appeals case, but other courts confronting the exact same scenario have concluded that have rejected their argument and concluded that a purchase can be made with something other than cash. That's the Serta case cited at page 11 of our reply brief, and that's the Murray Energy case cited at page 21 of the company's reply brief. Both of those cases confronted the same issue. They may grapple with whether or not something is an open market purchase, but that's not the issue here. The issue here is whether something was a purchase, and of there, I think the cases are uniform.
Thank you, Counsel.
Thank you, Your Honors.
Who do you have, sir?
May it please the Court, Paul Regani of Warwick for Credit Suisse. So I join in full the arguments that my colleagues made about the implied covenant, but want to highlight some additional reasons that the implied covenant claim is particularly inappropriate as against Credit Suisse. And it starts with the observation that Justice Higgett made about the implied covenant, which is that no matter what you do with an implied covenant claim, you can't contradict the direct terms of the agreement. And here, the direct terms of the agreement in two places are that the administrative agent, the role that Credit Suisse fulfills, shall not be held to any implied covenant and shall not be held to any implied duties. That's clear and explicit on the face of the contract. And what the plaintiffs are trying to do here, when they agreed at the outset that Credit Suisse wouldn't have those implied duties, when they're disappointed with something that happened, now they want to come in and sue Credit Suisse for breaching duties that they agreed Credit Suisse wouldn't have. Now, we cited 6 cases, to Your Honor, enforcing provisions exactly like these by barring implied covenant claims, and those include 2 decisions of this court. Those are the fixed income shares decision and the STS partners decision. And those cases honor the bedrock rule of New York law that you hold sophisticated parties to the terms of the bargains that they reached. And plaintiffs don't have any authority going the other way. They don't cite a single case refusing to enforce an express agreement that an agent in Credit Suisse's shoes would not be held to implied covenants. The additional reason that the implied covenant claim doesn't work against Credit Suisse is that Credit Suisse was acting in accordance with a direction from the majority lenders. And again, there's language expressed in the agreement in section 8.04 where the plaintiffs agreed Credit Suisse would be fully protected and would not face liability when it acts in accordance with a majority direction. So unless there are any questions on that, I do want to turn briefly to the tortious interference claim, because the allegations on the face of plaintiff's complaint that Credit Suisse was motivated by its loan to Mitel established the economic interest defense in Credit Suisse's favor. And that's because a lender has a contractual right to be repaid, that the law permits that lender to prioritize over someone else's contractual right absent malice. And there's no plausible inference of malice here where the alleged motive that Credit Suisse had was that it wanted to have its loan repaid. That's the only allegation of motive that's made in the complaint, is that we were motivated by our economic interest in ensuring that Mitel was able to repay the loan, which courts, in the context of a motion to dismiss, have cited as establishing the economic defense in the defendant's favor. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honor. Chris Harris for Searchlight, and thank the court for allowing my colleague, Michael Byrne, who's been admitted pro hoc, to argue.
Very well.
Good afternoon. Thank you, Your Honor. May it please the court. I'll just be very brief. We represent Searchlight Capital Partners, Mitel's owner. No matter how the other issues in this case come out, the trial court properly dismissed plaintiff's tortious interference claim against Searchlight under the economic interest doctrine. In a nutshell, the economic interest doctrine provides that when you have an economic interest in another party, you're privileged to interfere with that party's contracts in order to protect your own economic interest in the company. And here, with respect to the transaction at issue, plaintiffs acknowledge on page 14 of their brief that the right inquiry is not to look at whether Mitel got the best deal from this financing transaction, but simply rather Mitel had an economic interest in the deal it got. And here, where it received hundreds of millions of dollars in financing that it then utilized in order to complete a transaction, it's very clear that Mitel had an economic interest in it. It's also acknowledged at page 40 of their opening brief where
It is unusual, though, on a motion to dismiss that's not grounded on CPLR 3211A5, which enumerates the various affirmative defenses that are recognized to be used on a 3211 motion, we employ an affirmative defense under 3211A7 or A1.
Well, actually, we point out in our brief that the defense of the economic interest doctrine is routinely utilized to dismiss cases in New York in response to tortious interference claims. So this is something that's quite routine, particularly where it's on the face of the pleadings. And here, you need to go no further.
I guess that's how you employ it then, because failure to state a cause of action, it's not failure to overcome an affirmative defense, but I guess it's the face of the pleading manifests the merit of the affirmative defense.
That's exactly right. And here I'll just point, if I may, briefly, Your Honor. Paragraph 5 of their complaint, they say Searchlight directed, this is before the transaction, Searchlight directed Mitel to enter into a partnership with Ring Central that would allow Mitel to fund another acquisition and pay down its debt. That Ring Central transaction, they then allege, didn't work out well. The funds that Mitel expected to come didn't come, and that's what created the necessity and the interest in receiving additional financing. Thank you, Your Honor.
Thank you. Plaintiff.
Thank you, Your Honor. I'll try to do this all in 2 minutes. So on the good faith claim, we had a statement that the contracts allow non-pro rata transactions, but we submit they don't allow this non-pro rata transaction because of the result, which was to subordinate us, and because it was done in a way that the loans were acquired at well above a market price, which resulted in a giveaway of value from the company to the defendant lenders.
So we're talking about now the manner in which they exercise their discretion.
Correct.
To obtain fresh, non-pro rata debt.
Correct. So even if they had the discretion to enter into this deal under the contract, and again, we bring this in the alternative, assuming that they're right on the contract, the law is clear that they can't abuse that discretion or exercise it in a way to deny us the benefit of the bargain.
They can't do it arbitrarily, and they can't do it irrationally. Here, weren't they doing this even from the face of your own pleading? Didn't they take on this fresh debt because in the wake of a transaction another transaction that had went south and cost them to sustain some pretty significant losses?
Your Honor, the standard is whether they denied us the benefit of the bargain. That's what AEA and Credit Agricole say. They say that even if you comply with the contract, if the defendant's act deny us the benefit of the bargain, we can use the implied covenant to enforce our reasonable expectations. And I heard my friend say, oh, well, AEA turned on other language where there was a categorical requirement of non-pro rata treatment. No, it did not. That provision was discussed, but only in the context of discussing contract claims. If you go back and look at AEA, that is not what the good faith ruling turns on. It turns on allegations of conspiracy to deny minority holders the benefit of the bargain, and that's exactly what happened here. I also heard several times from the other side that these were sophisticated parties, but under that logic, there could never be an implied covenant claim between sophisticated parties on a contract like this, which we don't think should be the law. And in terms of whether Credit Suisse could waive being subject to the implied covenant, we'll just stand on our briefs for that point. Quickly, on the tortious interference claim, I heard the other side say that we allege that Credit Suisse acted to protect its interest in a loan to Mitel. That is incorrect. There was an existing loan to Mitel. Their interest was in that loan. What they acted for was not protecting getting paid under that loan, but getting an early payment, which would be a new term, and replacing that loan with a new loan on better terms. That's not protecting an existing interest. That's trying to get a new interest, and that was outside of their existing economic interests. I also heard our friends say that Searchlight was privileged to do what they did. What they're basically trying to do is turn the economic interest defense from an affirmative defense into an immunity that says if you hold equity in a company and you have a general interest in it, then somehow the tortious interference claims can never apply to you, and we know that's not the case. There was also a question about what the face of the pleadings say. What I would ask you to look at paragraphs 201 to 204 of our complaint in terms of what we allege about Searchlight. And remember, you have to take the inferences in our favor. They're telling you a different story about what they did and why and how it helped Mitel. We have put forward a very credible story that what they did here hurt Mitel and was done simply to benefit their relationship with the defendant lenders, and we think that's enough to defeat their economic defense. If I have time to quickly address the contract. So there was we just don't think that they can overcome their burden of having to show that the contract is unambiguous in their favor. The question of whether there was direct and adverse effect, we were directly and adversely affected. This transaction happened in an instant, and as a result of that, our loans were subordinated.
Indirect effect. What you're arguing is really an indirect effect, isn't it?
No, it happened all at once. The transaction, it was an integrated agreement that happened all at once, and as a result of that, in that transaction, we wound up immediately subordinated under $860 million of debt. The market...
But your sacred rights didn't include a protection for your priority, only for your principal, your interest rate, and your maturity date.
The sacred rights contained two protections. One was it said that the company couldn't reduce the principal amount of any loan without the consent of any lender directly and adversely affected thereby. When they exchanged and took back the defendant lender's loan, they reduced the principal of their loans to zero.
But it didn't affect anyone in your class, in your tranche.
It absolutely did, because that reduction of principal was part of an exchange of their debt, which immediately caused us to be subordinated under all this additional debt. And the question is whether the agreement or agreements harmed us, and they clearly did, because we wound up as fourth and fifth lien lenders when we had gone to bed as first and second lien lenders. And they can present a different alternative explanation for that, but again, we don't think you can resolve that on a motion to dismiss, and the court was right about that. There was also an assertion that they didn't amend Section 7.02 because they simply introduced a new intercreditor agreement. 7.02 incorporates the terms of intercreditor agreements on its face. You put in a new intercreditor agreement, by definition, you have amended the terms of 7.02. If that were not the case, then this sacred right would have absolutely no meaning. You could just amend waterfalls willy-nilly, and it would have no effect because you weren't actually changing anything except the intercreditor agreement. Then finally, there's a question of whether this was a purchase. They called it an exchange when they did it. They didn't exchange any cash or cash equivalents for it. We don't think they can show unambiguously that this was a purchase. The last thing was they said we could just put in anti-certa provisions, but nobody knew about this at the time. And that is a question of fact. It is a question of fact what reasonable holders would have expected. And all we're asking you to do is revive our claims. If you do so, we're confident we can prove this through the testimony of traders, through the testimony of experts. No reasonable holder would have expected this. Searchlight was acting for its own interests, not for Mitel's interests, and we're asking you to give us that chance by reviving our claims. Thank you.
Thank you.
Your Honors, I'll try to be brief. I only have 2 minutes. With respect to the so-called sacred right on reduction of principal, the language in the contract is the only lenders that need to consent are those directly adversely affected thereby. They don't allege direct, nor do they allege thereby, because it wasn't their principal that was being reduced. So I think that's two reasons why that argument doesn't work. With respect to 2.18b4 relating to subordination, there was no amendment whatsoever to 702. 702, the words didn't change, and 702 on its face speaks in terms of any applicable intercreditor agreement. Intercreditor agreement is a category that was predefined. So entering into a new intercreditor agreement without actually changing the words of 702 or the definition of intercredit agreement. It's just not an amendment. Amendment means change the words. A couple of other points, Your Honor. I argued earlier why we don't think the Dalton discretion framework really works here, but even if it did, what Dalton speaks of is, as Your Honor pointed out, arbitrary or irrational. This was anything but arbitrary or irrational. Mitel got $150 million of new financing, and with respect to the purchase transaction, it got debt back in exchange for through the purchase in exchange for debt that had a longer maturity and lower principal amount. So there were economic benefits. It's the opposite of arbitrary or irrational. And finally, we're certainly not saying there's no implied covenant ever when you have sophisticated parties. What we're saying is that where the sophisticated party is reduced to writing in extremely detailed, specific terms, the scope of a right, in this case, the right to pro rata treatment, and they allow non-pro rata transactions, and they specifically define the limit of what can be amended and what can't, there's no room for an implied covenant there. Thank you, Your Honor.
Thank you.
Your Honors, I'll be very brief, and again, I'll represent the participating lenders. With respect to the good faith and fair dealing claim, I think it's all been said. The only thing I would add to gild the lily is just that my clients aren't even the borrower here. My clients are just fellow lenders. And so all of the contractual provisions that are cited by the other side, most of them don't even have anything to do with my client when it comes to an end run with respect to the good faith and fair dealing claim. So that's just a bit of perspective with respect to where my client stands. On the sophisticated parties point, counsel said it well. You have an exception here that is on the face of the document, and that was not amended. That exception was not amended. 9.04I was not amended, nor was 2.18C by the amended agreements. And so, I hear counsel saying, how could we know? We couldn't know that the exception would be used. Well, the exception is sitting expressly in the document, so I'm not sure that complaint holds water. And then the final point that I would make, Your Honors, is that counsel didn't have much to say at all about why the purchase exception was not properly invoked here, and why a purchase needs to be in cash and cannot be in any other form of consideration. And so we would simply rest on all of the case law that I noted before, and would suggest to Your Honors that it's quite uniform that a purchase can be something other than cash money. It can be other things, including debt. And I don't think that there's case law that says to the contrary, that it exclusively must be cash. If we are
fairness to your friend, he had a lot of other terrain to cover.
fair enough, but I think our written presentation is also overwhelming on this, respectfully. But I would simply say that there is not a case, I think, that says it must be cash and cannot be anything other than cash. And if we're right about that, then the contract claims would have to be dismissed because we've properly invoked, and the company has properly invoked 9.04I. Thank you very much.
Thank you, counsel. I have to apologize. Pena versus Rhodes 2. Yeah.
Benjamin Zepnik for the defendant respondent. The defendant appellant for the first time and improperly for the first time in the reply brief raised arguments relating to our cross claims, and therefore we did not have a full and fair opportunity to address those arguments, and therefore the court should not consider them. I would direct this court to its decision in the Erdy versus City of New York case, ERDEY 129 AD 3D 546, where this court rejected arguments which were, quote, improperly raised for the first time in his reply brief, end quote. And to the extent that this court does consider those arguments, we would rest on our respondent's brief.
Thank you very much.
That is all. Thank you.
And next, we have Meyer versus Hughes. Whenever you're ready, counsel.
Your Honors, may it please the court, my name is Frederick Gaffney. I represent the appellants in this case. Dr. Shauna Hughes, who's an OBGYN.
Could you talk into the mic, please?
I'm sorry, Judge. I represent the appellants in this case, Dr. Shauna Hughes, an OBGYN MD, as well as the related co-defendant, Bronx Westchester OBGYN. That representation, Your Honors, arises in connection with the appeal now before this court, which arose from a motion that we had made to amend the complaint to include an affirmative defense of lack of capacity to sue. Going back to a very brief timeline, Your Honors, the plaintiff claims, Ms. Rios, that she was subjected to malpractice in 2017 in a surgical procedure. Thereafter, and in 2019, she filed a claim for her personal bankruptcy, which did not include the co-plaintiff, her husband. In 2020, represented by the same firm who represents her in this action today, she filed an action in Bronx Supreme claiming medical malpractice et al. In connection with her claims that arose, she claims, in 2017. We became aware of this very shortly before the examinations were to go forward. And I believe plaintiff's counsel will also tell you that they were unaware of the fact that the bankruptcy had been filed. We did not wish to go forward with those depositions. In that case, we couldn't, I believe.
You want to get to the substance of your argument, sir?
The substance, Your Honor, is that the plaintiff, Rios, did in fact lack complete and utter capacity to sue. Since she lacked capacity to sue, making her the plaintiff in this case, the law is crystal clear. In a bankruptcy proceeding, the bankrupt estate takes on all assets of
Why can't there just be a simple amendment here? And the bankruptcy trustee becomes the proper party with standing to bring the lawsuit?
Because, Your Honor, of the fact that to substitute the bankruptcy trustee in currently in lieu and instead of the plaintiff Rios, Rios has no capacity. He has nothing to succeed to that is justiciable. She had no capacity when the action was begun, was initiated. So therefore, to substitute him in would prove absolutely nothing, would accomplish nothing.
It's not as if she lost capacity, I guess, so to speak, during the pendency. Is that at the outset, she had nothing?
At the outset, Your Honor, she had no capacity. She had filed a bankruptcy petition in 2019 that deprived her of the ownership of everything she had, including the chosen action relating to the malpractice claim. So to attempt to substitute in a different party to assume as a successor to a person who had no capacity, in fact, it just can't be done. It was a nullity when the suit was filed, and very quickly, Your Honor, I will note that the judge below, Alicia Garez, agrees with what I just said. She said the bankruptcy court only and not the plaintiff had the right to bring this suit. The bankruptcy court owned the tort, the cause in action, but she says that somehow there's a federal situation here that compelled her to sign an order, even though the federal court motion asked her to entertain a motion at most, did not compel substitution, but indeed, that is the basis that she allowed this to go forward.
If, assuming we were to agree with you that there was no standing or capacity, however you want to put it.
Yes, Your Honor.
Would the dismissal be with prejudice or without prejudice?
With prejudice,
Why?
clearly. Because, Judge, there is no, what transpired here is a matter of.
So why can't the bankruptcy trustee now bring their own action? And maybe it's subject to dismissal on statute of limitations grounds.
It is subject. It is
maybe
subject
it's
to dismissal.
not.
I believe it definitely is, Judge. It definitely would be subject to dismissal on. If you consider the 2007 I'm sorry, Judge.
Unless CPLR 205A applies.
That is entirely a different question, Judge. We know that.
So then why shouldn't the dismissal be without prejudice? And so that the issues of statute of limitations, application of 205A.
Because I think that, Judge, would be a material alteration of the actual facts as they exist. In fact, number one,
But we're not deciding it on the merits. All we're doing is saying, if we agree with you that that the plaintiff in the first instance shouldn't have brought it, there may be another party that's entitled to bring it.
But I can think,
Bankruptcy trustee.
but with all due deference, Your Honor, I can think of none. First of all, 205A and the 3-year-old Court of Appeals case put substantial doubt into this entire issue, which is not for today's argument.
That's not before us.
But, Judge, I don't see how you can possibly reconfigure these facts so as to allow a person who lacks, she sued on someone else's case, and now we're saying you can substitute out, provide that to a successor or an interest, and somehow come out of this as if this hadn't transpired? I don't think it's logically or jurisprudentially possible, Your Honor.
Thank you.
Thank you, Judge. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court. My name is Gina Bernardi DeFalco. I'm here on behalf of all of the appellants that weren't listed by counsel. I won't go through all of your names. Just very briefly, to answer Justice Singh's question as to why there can't be a simple substitution, because the Court of Appeals has said so. If a case is brought at a time when a plaintiff does not have capacity, you cannot correct it by the expediency of amending the caption and substituting in the proper plaintiff. There were 3 cases, Goldberg, Carrick, and then there's a third department case, In Re Plastics, all cited on page 2 of my reply brief, as well as in my appellant's brief. As Your Honor pointed out, Ms. Rios did not have capacity at the time she brought this lawsuit. She brought the bankruptcy action before she filed suit. Her counsel, Mr. Messer, her counsel and Mr. Messer, the trustee, were well aware of the suit before it was brought. Mr. Messer, in fact, brought an application in the bankruptcy court to retain Siegel and Coonerty as counsel to prosecute this action on his behalf so that he could secure assets on behalf of the creditors. In the meantime, counsel and Ms. Rios brought suit that they knew they had ceded the right to bring, that Ms. Rios had ceded the right to bring at the commencement of her bankruptcy, 541 of the Bankruptcy Code. This was improper. Mr. Messer cannot now come in and substitute himself. He let the statute of limitations lapse. When the bankruptcy court...
If you're correct, should the dismissal be with or without prejudice?
I'm going to respectfully disagree with my colleague. I believe it is without prejudice. However, Mr. Messer is out of the box. The statute of limitations is gone. The Court of Appeals has revisited the issue of 205. It has to be the same plaintiff. It has to be Mrs. Rios.
Well, but I think there's some wiggle room in the footnote by the Court of Appeals there with bankruptcy trustees.
Well, I think they haven't explicitly addressed the question. However, the language that they use, that is also quoted in my reply brief, which I won't bother the court to read, but specifically the middle quoted paragraph on page 16. For decades, we've been allowing plaintiffs other than the named plaintiff to bring this case, and we should not be doing that because that's not what the statute says. I think it's pretty clear that Mr. Messer cannot come back. Everybody has unclean hands. Everybody on the top side of the V has unclean hands. Ms. Rios went to the bankruptcy court, and despite that, she went and brought a lawsuit. Mr. Messer was aware of the lawsuit. The bankruptcy court allowed him to hire counsel in January of 2020. He had a toll.
This isn't our standard case where there's just a complete failure to list it on the appropriate bankruptcy schedule as a an asset. It was a little clunky that there's some reflection of this as a potential asset of the bankrupt party. There were some orders issued by the bankruptcy court that attempted to facilitate this. So it's not our standard failure to list, and now we know clearly and unambiguously the consequence.
Correct. And in fact, the plaintiff has raised in their opposition that the fact that it's listed should make a difference as to whether you should substitute. But that doesn't change state court rules about how you correct capacity. You don't do it this way. The Court of Appeals has said you don't do it this way. And the bankruptcy court did not tell the trial court to grant the motion. They told the plaintiff to make the motion. They ceded that decision to the state court under state court rules. She 100% erroneously copped under federalism principles and the supremacy clause. I addressed it in my brief. It doesn't apply here. Plaintiff did not even respond to that argument in their opposing brief. So that was error. This case should be dismissed. And the question of whether or not it can come back later should be deferred to when and if
Thank you.
a plaintiff attempts to do so. Thank you, Your Honor.
You may proceed, counsel.
Thank you. Good afternoon. My name is Stuart Diamond. I'm here on behalf of the plaintiffs' respondents.
So what happened here?
What really happened?
I mean, I don't understand why the lawsuit was brought when it was already listed on the.
It was just, the record actually reflects this to the extent that there's an indication, and it's cited on page 2 to 3 of our respondent's brief. There was an attorney who left the office. They did know about the claim. They intended to bring it in the name of the trustee. That's not been hidden. And in fact, the bankruptcy court said in their order, there's a pending, obviously the court knew that there was a pending action. What they're asking this court to do is really novel, and it's something, at least in the cases that the three of us found, no court has done before. Dismiss a case because of the bankruptcy, holding that a bankruptcy trustee cannot prosecute an action where the debtor listed the claim as an asset of the estate. In none of the cases they cited where there were dismissals was that the fact, where as Justice Higgett pointed out, in this case, and they never raised the issue that the listing was somehow deficient. In this case, the debtor listed the asset, listed the claim as an asset of the estate.
Did plaintiff have permission from the trustee to bring the suit?
What the bankruptcy court, yes, the trustee was on board. What the bankruptcy court gave was permission to make a motion. That's true. But if you look at some of the other cases, including one that was relied on by the trial court, the Berry case, it's the exact same language. In fact, in Berry, it was the exact same trustee. In at least 3 of the cases that are cited between the 3 of us, that was the language of the order from the bankruptcy court. You may make the motion. They make a point that the bankruptcy court didn't say the motion had to be granted, but if you read that order, it spoke about how the asset, how the recovery, and who would approve the settlement and payment of an attorney's fee. So it was clearly the intention, as in these other cases of the bankruptcy court, that the motion would be granted. It was just an oversight, and this is in the record. It was just an oversight that the motion wasn't made. That's the key distinction. This is a unique case, and it's not an inconsequential fact.
But if the plaintiff lacked capacity, isn't the remedy dismissal and then the trustee brings a separate action?
We don't think so, because we don't think as to the first part, because as the court said, there's also the issue of, the court cited 2 cases, Berry and Fawcett. In Berry, they called it a supremacy clause issue. In Fawcett, the appellate division said it was a matter of comity between the state and federal jurisdictions. And even in the Ace case, the Court of Appeal, the recent Court of Appeals case, at the end of the case, as Your Honor pointed out, the court made clear, the very least strongly suggested, that they said this is not a bankruptcy case, and we're not saying how we would rule if this was a bankruptcy case. For that very reason, there are federal, state issues, including the supremacy clause, that are implicated in this case.
Tease up that issue.
If we get to the second issue, which is 205A, this is clearly not one of the 3 exceptions to 205A. We cited a case called Goodman, an appellate division case from the Second Department. Same facts, trustee was...
But I don't think that issue is really before us. Would you agree? The 205A issue is really not before us.
It was part of our cross motion, and we didn't appeal it because we weren't aggrieved. So...
Well, procedurally, it's sort of the 205 academic, I think, the 205 issue is academic until you bring a new action, and then the defendants challenge that action as time barred, and then you invoke 205A, and then you get a determination. I think that's normally how that's teed up, so to speak.
We would suggest that the court would be within its rights to, if it does decide that the case should be dismissed, to specifically state that it's without prejudice to recommencement under 205A. We think the court can do that. And I think that's basically what happened in the Goodman case and the other cases. We cited 7. They didn't neither appellant addressed the Goodman case in their reply brief. We also cited 7 cases on pages 13 to 14 of our brief, addressing the issue that they raised, that there can't be a switch between the plaintiffs. And in the 7 cases that we cite on page 13, where they said that the important issue was whether there was a lack of capacity in the first instance. We cited 7 cases, none of which they addressed, in which the same facts applied. There was an issue of whether, in the first instance, there was a capacity to sue, and the court, in those cases, invoked 205 and allowed the case to be recommenced. Thank you.
Thank you, counsel. Please, got 2 minutes.
Just one quick statement, and that is the idea of whether or not this case, or a potential case as it was worded, is of relevance here. I don't believe it is. Nothing alters the fact, the jurisprudence is clear. The bankruptcy estate owns that cause of action. Any attempt for anyone else to litigate it results in a nullity, and thereby the concept of swapping the trustee with the interest of the plaintiff when she had none cannot be accomplished. Thank you, Your Honor.
Anything you want to add?
Just quickly. I'll be as quick as I can. Both the Berry case and the Fawcett case are distinguishable. Justice Pitt, you brought up the distinction early on. In those cases, the plaintiff brought the lawsuit before the bankruptcy. That is key. The bankruptcy code 541 is 100% clear. The minute the action is commenced, it is the commencement of the action that divests the debtor of their assets, period. And while I didn't address each of plaintiff's cited cases by name, I did distinguish them en masse on the point that Justice Higgett raised, which this is not the case where the plaintiff didn't list it. She brought it. It got dismissed. She had to go back to the bankruptcy, reopen the bankruptcy. This is a case where the trustee knew. The trustee knew there was a case, and there was a toll because of COVID of 228 extra days. He had 6 months after the bankruptcy court authorized him to retain Siegel and Coonerty. They could have brought a separate action in his behalf. They had time, and they blew it. And the defendant should not have to pay for that. And the Court of Appeals has said, no, substitution is not the answer. So this case should be dismissed. And the 205 issue should be kicked to the next action. Thank you, Your Honors.
Thank you all.